Thank you.
Diana Kingsbury is raising her hand, so I'm going to go ahead and allow her to talk real fast before we start up, if that's okay.
Hi, can you hear me?
Yes, yeah. Diana, hi.
Hi, so thanks all for being here. I just wanted to check in about the recording. I know we've shared some concerns from tenants for their privacy, and just wanted to check in and see, I guess, who would be sharing what information about tenants tonight so that everyone can feel safe participating.
Well, we're planning on recording the webinar, and tenants are free to participate as they like, and share what they would like, and not compelled to share anything they are not comfortable sharing.
Can I suggest something? I think that, but they don't have to identify their name. We don't need, they can be anonymous, Diana.
Okay.
Yep.
Right, thank you.
Yeah, no, thanks for the question.
It's a good question, and we are recording, and we've been asked by several people to post this recording. So just anyone who's speaking, just know that, and like any other public meeting, this will be recorded and shared on our website.
Okay, got it. Thank you.
All right, well, it's 6:01. Should we start the recording and get, oh, the recording already started, so.
Yep, but we can
Okay.
we can launch if that's all right, and folks can join us as they are able.
Yeah. And before we start, should I turn on the interpretation services now, or do we want to wait until we've introduced them?
First introduced, yeah.
Right. Okay.
So thanks. Good evening, everyone. Thank you for joining us tonight for our webinar on the City of Petaluma tenant protections regulations and our process, whereby we'll be returning to the City Council with those for them to consider potential amendments and community input regarding the city's regulations. My name is Eric Danley. I'm the city attorney. And at this point in our webinar, I'm gonna ask the City of Petaluma representatives and our partner, Elise Hempel with Petaluma People Services, to introduce themselves. And I don't know, Ingrid, if you want to facilitate that, or we'll just take turns.
Sure, I'll start. My name is Ingrid Alverde. I'm the Director of Economic Development and Open Government. Lisa, I'll pass it to you, and then you can pass it forward.
Hi, everybody. I'm Elise Hempel. I'm the Executive Director at Petaluma People Services Center, and we've been a partner with the City of Petaluma in providing fair housing for over 35 years. And I'll pass it off to Dylan.
Was it me? Sorry. My name is Dylan Brady, Assistant City Attorney, and I will popcorn to Karen.
Good evening. My name is Karen Shimizu. I'm the housing manager with the City of Petaluma, and I will pass it off to Sarah.
Good evening. I am the housing specialist. My name is Sarah Wolf, and I work closely with Karen Shimizu and Jameson.
Hi, everyone. I'm Jamison Bunn. I'm the Communications Manager for Petaluma. And I will pass it over to Erin, my colleague.
Hi, everyone. I'm Erin User. I work closely with Ingrid and Jameson to do community outreach to make sure that people like you show up to events like this. Thanks for being here.
Don't forget our city managers here, Peggy.
Oh, yeah.
That's okay. I'm just here for the ride.
I forgot
I'm
the
Peggy- I'm
popcorn.
Peggy Flynn, and I am your city manager in Petaluma.
And I think that's all of us. So Christina, you want to introduce and Mariana, and then we'll get started. Mariana? Yeah.
Hi, this is Christina, and I am your interpreter for this evening. And I pass it on to Mariana.
Thank you. My name is Mariana Rivarola, and I'm also interpreting today for you all in case you need Spanish interpretation.
And
Thank
then
you.
do you want to, in Spanish, let everyone know that Spanish will be available, and then we'll turn on translation, and then Eric, you can start the meeting?
Yes, perfect. A todos los que necesiten escuchar esta reunión en español, tienen la opción de seleccionar donde está un icono de un globo mundial para poder ahí seleccionar el idioma de preferencia. Si es que necesitan español, ahí van a tener el servicio de Cristina y el mío de traducción simultánea. Gracias. Thank you, everyone.
So do we have the translation feature running? We're good to go. Okay, thanks for the introductions, everyone. Again, if there are folks that have just joined recently, my name is Eric Danley. I'm the Petaluma City Attorney. I'm here with our team that's been working on the city's housing regulations and outreach about them, so we can return to the council and get their direction for possible amendments to those in response to community feedback we get from all interested stakeholders, including tenants and landlords and just interested members of the public. So this is the first of 2 community workshops that we're holding. This one's virtual. The next one is going to be in person at the city's community center, the Lucchese Center. So some of you may want to join us then. So please feel free to do that. I'm going to talk briefly, just cover what we're going to cover tonight. I am going to try to pause between my comments like I usually do not do at city council meetings because we have translation. So I'm going to try to do a better job. So following our introductions, we're going to share a number of slides with you. They are going to cover an overview of the current state law regarding both rent control and tenant protections, and that's the Tenant Protection Act, as well as the Ellis Act that relates to the rights of landlords to remove their properties from the rental market because we've implemented regulations under that too. And after we cover the state law, we're going to compare the state law with the city's regulations. And the reason we're going to do that is to try to have everybody on a level playing field and a good understanding of what we're talking about and why the regulations do what they do and what they do, so as to facilitate people asking questions and having clarity, and also help with people thinking about what they may like or dislike about the regulations or what kind of suggestions they may have for changes. And then after we cover the law and do those comparisons, we will be here for really the main focus of this webinar today, which is to answer questions and receive your feedback, because we're going to be taking that information to the council to inform their deliberations on the city's regulations. And finally, we'll talk about next steps. We'll talk about the next public workshop. We'll talk about the workshop that we'll have with the council, at which we won't be presenting legislative drafts. We'll just be presenting a menu of options. That's what the council specifically asked us for, so that they can make legislative choices and direction. And then we will return, if that's their direction, with potentially updated regulations. So could you open the slides for me, Ingrid, if you don't mind? There's the overview I just talked about. And if you could go to the next slide. Thank you. So again, I think many people may be familiar with these basics already, but we're going to cover them briefly, just so that we're all a good starting point for understanding the regulations that the city has. So some basics just about landlord-tenant law. Leases are contracts. They protect both landlords and tenants, and they're governed by state landlord-tenant law. Fair housing rules apply to all residential tenancies. They prohibit discrimination. They establish landlord duty to maintain properties in a safe manner. They establish unlawful bases for terminating rental agreements, etc. It is these requirements that Elise, who introduced herself earlier, and her team at PPSC helps maintain and implement for the city as a longtime partner, as you heard, for 35 years, working with the city to help provide housing stability. So our local regulations do not amend your leases or tenants' leases with landlords. What they do, as you'll see when we talk about them further, is limit the justifications, the lawful justifications for terminating rental agreements, and they also provide remedies or penalties for violations of our regulations. Next slide, please. So here's a quick high-level historical overview of tenant protection law in California that we're going to be talking about tonight. The Ellis Act, as I mentioned already, is state law that recognizes a right in landlords to remove their property from the rental market. The Tenant Protection Act is a quite recent law. It was enacted just prior to the COVID pandemic. It limits the lawful grounds for landlords terminating rental agreements, and it also establishes statewide rent control. And we'll discuss that in greater detail. There were urgency enactments in Sonoma County in response to the wildfire emergencies and the COVID pandemic that the county enacted under the Emergency Service Act powers that it has, that provided some protections from evictions. It was just around the time that the county COVID financial distress protections were about to expire that our city council directed us to bring to them for adoption an urgency ordinance that would extend in Petaluma the COVID eviction protections. And so we did that, and they enacted that, and it was only to be in effect until the interim regulations took effect, and the council did adopt interim regulations that we're going to be spending some time talking about tonight, which add protections in addition to those in the Tenant Protection Act, and also which implement protections concerning properties being removed from the rental market as allowed by the Ellis Act. Next slide, please. So what the Petaluma regulations do and do not do, they do limit terminations of rental agreements. They do require noticing to be provided to tenants. They do regulate removal of rental properties from the rental market, but we do not have local rent control. It's the Tenant Protection Act, the state law, that provides that. Next slide, please. Did you want to add something, Ingrid?
No, sorry.
Oh, that's okay. Would you go back?
Sorry.
There we go. Thanks. So the Ellis Act has been in effect for a while, since 1985. It has a section that permits local regulations that we have in fact implemented. We'll talk more about those shortly. The Tenant Protection Act is from 2019. And it, as I just noted, It allows local regulations as long as they're more protective than the Tenant Protection Act. And ours are. And so that's the authority that we have for the city's regulations, and they limit just causes for evictions as well as provide rent control. Next slide, please. So the Petaluma regulations build upon the Tenant Protection Act. They don't have rent control, but the Tenant Protection Act does, as they must to be consistent with our local regulatory authority. Under the Tenant Protection Act, they provide additional protections. And as I mentioned, we implement Ellis Act protections too. Next slide, please. Still staying at a high level, what does the Petaluma ordinance do in relation to the Tenant Protection Act? We eliminate some of the exceptions in the state law, which has the result of providing for more protection. We provide the protections of our local regulations sooner in a tenancy than the Tenant Protection Act does. We reduce some of the grounds for termination of a rental agreement that are allowed in the Tenant Protection Act, and we revise some of the definitions, and we'll talk about all those things further. So under the Tenant Protection Act, under the state law, it doesn't start protecting tenants until they've lawfully occupied their rental unit for 12 months. In the Petaluma ordinance, it starts to provide protections after only 6 months for most tenants, but it requires the full 12 months where the landlord lives on the property, or the rental unit is an accessory unit to the main property. Next slide, please. So regarding the Tenant Protection Act, it applies to units that are received. I'm sorry, these are the exceptions under the state law. So it applies to units other than the ones we're listing here, which is units that have received their certificate of occupancy in the last 15 years, units that are restricted to affordable housing, dormitories owned and operated by schools, nonprofit, hospitals, churches, and extended care facilities, and owner-occupied properties where the property is their primary residence, and it shares a bath or a kitchen with the tenancy. Continuing with the exceptions in state law, it also does not apply to owner-occupied duplexes, where that's the owner's primary residence, and they've occupied it since the beginning of the tenancy. It doesn't apply to single-family homes if they're owner-occupied and the owner leases no more than 2 rooms. It also does not apply, and this is probably the biggest exception in the state law, it does not apply to single-family homes if the owner is not a corporate entity and the tenants receive notice of this exemption under the state law that they're not covered. It also does not apply to hotels and transient occupancies, so short-term occupancies. So now we're going to talk about the coverage of the Petaluma ordinance. It does not apply to units owned or subsidized by government agencies. It does not apply to units occupied by a tenant property manager. It does not apply to developments with more than 49% of the units restricted to be affordable. It also does not apply to units where the primary resident is the owner and shares a bathroom or kitchen. But otherwise, it applies to all rental units in Petaluma. Next slide. Thank you. So going back to the state law, the permitted reasons for terminating a rental agreement under the state law are failure to pay rent, breach of the lease, causing a nuisance, talk about what that means, criminal activity, using the unit for an illegal purpose, committing waste, that's also a term in landlord-tenant law we'll talk about, subletting in violation of the lease, refusal to allow the owner to enter in accordance with the lease, failing to vacate after the tenant indicates to the landlord that they intend to vacate, and if it's an employee of the landlord failing to vacate after termination of the employment. Next slide, please. So here we're going to compare, Ingrid has prepared a graphic to compare the Petaluma ordinance. So those X's indicate that in the Petaluma regulations, we've eliminated those causes for terminating a rental agreement. So there are fewer lawful bases for terminating rental agreements under the Petaluma regulations. And there's also some qualifications. So the criminal activity reason requires an eviction. There's an exception for if the tenant is able to remove the source of the illegal activity from the unit, and also a provision that says if the tenant is a victim of domestic violence, that's not a basis for termination. And there's also a provision that says landlords can't refuse to accept rent payments from third parties if doing that results in a basis for terminating the rental agreement. Next slide, please. Thank you. So state law summary. No fault basis for termination, meaning that it's not the tenant's fault that the rental agreement's being terminated. Under state law, that can happen when the owner wants to remove the unit from the market. That's the Ellis Act rights they have. Or when the owner or family member wants to occupy the unit, or when the unit needs to be substantially rehabilitated, or to comply with a government order. And if they do that, then they're required to provide relocation benefits of 100% of 1 month's rent. Next slide. So the Petaluma regulations, the owner can terminate when in accordance with their rights under the Ellis Act to remove the unit from the market. They can do it when the owner or family member wants to occupy the unit, but they must move in within 90 days and stay for a year. And there's an exception for disability accommodations. There's also a provision in the Petaluma regulations that limits termination during school year for Petaluma teachers and K through 12 students. And it also provides a window in July when terminations can occur. The substantial rehabilitation reason is included in the Petaluma regulations, but the property owner needs to get all their permits before they give notice. Next slide, please. So we've talked about the student protection. Another provision in the Petaluma regulations is the relocation assistance increases to 150% of rent if the tenant is under 18 or over 62, low income tenant, is disabled, or a long-term tenant as defined in the regulations. Next slide, please. So these are no fault provisions in the Petaluma regulations. Or in other words, this is the city's implementation of the Ellis Act regulations that local agencies are permitted to adopt. So when the landlord intends to withdraw the unit from the market, the tenant whose rental agreement is being terminated without their fault has the right to return on the same terms with rent adjusted as it would be permitted to be under the Tenant Protection Act for the first 5 years, and within 10 years at the then applicable rental rate under the Tenant Protection Act. So there's remedies in the city's regulation if the owner or family member fails to occupy the unit within 90 days of termination or fails to remain for 3 consecutive years. And after rehabilitation of the unit is complete, the tenant also has a right to return under the city's regulations. Next slide, please. So other protections that are in the Petaluma regulations. The regulations require landlords to give tenants notice of their rights under the city's regulations. And that needs to be in English and in Spanish. And they need to provide the notice that the city has prepared and made available for that purpose. Termination of rental agreements in retaliation for tenants exercising their rights under the city's regulations is prohibited. The regulations also create a civil cause of action. That means a right to bring a private lawsuit against landlords allegedly violating the city's regulations. And successful tenants can recover their attorney's fees in those actions. And the city also reserves a right to enforce its violations of its regulations directly. Next slide, please. Additional features of the Petaluma regulations. The noticing needs to be in English and Spanish, and if the lease is in a language different from English and Spanish, it needs to be in that language. Notices are required for new leases and renewal of leases, and for rent increases, also for sale of the property, and in the event of changes to the Petaluma regulations. Next slide, please. So the no fault rental terminations, noticing is required to the tenant of the right to relocation, and the city is to receive notice if the landlord plans to move into the unit, and also if they're terminating the rental agreement for rehabilitation of the unit. Next slide, please. Okay, so now we're to the part where we're going to list some of the feedback that we've received from various stakeholders, just so you get a sense of what we've heard so far. But as I mentioned earlier, one of our main purposes tonight is to receive your feedback, and we'll add all the feedback we get to the list that we share with the council when we return in March for that workshop. So just going down the list, and we've got a few of these slides. We've heard that the right of first refusal under the Ellis Act lasting for 10 years is too long. It should be shortened. We've also heard that the additional 50% of the amount of the rent that is to be provided as relocation assistance for those folks I listed, like who are disabled or of a certain age or minors, that's excessive and should not be provided under the regulations. We've been told that the noticing requirements are excessive. We've heard about an issue regarding tenants at suffrage. That means a tenant who's remaining in the property after the lease expires, that those tenants shouldn't be protected under the city's regulations. We've also received comments about that say that landlords should be able to have rental agreements expire or be for less than a year, so they can return to their residence, such as in the case of being activated for military service or having a sabbatical leave, and that they should be able to do that without relocation assistance. We've received complaints about the protection for Petaluma teachers and K-12 students, that maybe those should be more limited or shouldn't exist at all. We've also gotten feedback that we should retain more of the exceptions in the Tenant Protection Act. Next slide, please. Thank you. We've also received feedback that there should be additional grounds for fault-based termination, which is another way of saying we should not eliminate some of the grounds in the Tenant Protection Act, like the regulations in the city currently do, and so that we should maintain committing of waste or refusing to enter a new lawful lease as a grounds for lawful termination. It's been suggested that the city's regulations should reduce or limit tenant protections when the landlord themselves qualifies as a low-income household. And we've also heard from some people that the council should not remove the expiration date and not renew the regulations, but they should be allowed to be expired because the Tenant Protection Act already provides sufficient tenant protections in the city. Is that our last slide, Ingrid, for the, let's see. Oh, so at this point, I'm going to ask Ingrid, who's our Open Government and Economic Development Director, to talk about the next steps since she's our community outreach leader in the city. Thanks.
Thank you, Eric, and thank you. So obviously tonight we're having a workshop February 1st. As you might be thinking, this is a fairly complex topic. Takes some time to absorb and understand, and depending on whether you're a tenant or a landlord, you might be thinking about it in different ways. And so we're also going to be doing a workshop in person on Saturday. We are going to be issuing a survey. It says February 4th. It may be early next week. We want to make sure we get that right. And the goal is for us to hear from each of you, answer questions so that the city council can host a workshop where the city council is present, continue this discussion, and so that they can give the staff direction on how best to move forward in terms of what to do about the ordinance that is set to expire on July 1 of this year. Our goal is to bring something forward for the council to review in March. You'll see on this arrow, it says first reading March 20 and second reading April 3rd. What that refers to is anytime we adopt an ordinance, it's required to be discussed by the city council twice. So assuming that we have a council workshop on March 6th and we have clear direction from council in terms of what they'd like that ordinance to say, then it would go back to the city council several weeks later for the council to review and either approve or not approve. And if it's approved, then it actually goes back to council one more time before it's adopted.
Thanks, Ingrid.
That is the last slide.
So yes, so now we're at the time where we get to hear from you all, answer questions and receive suggestions. And the team, the whole city team will all take part in fielding those. And that's really our focus for tonight. I hope the summary we gave you regarding the regulations is helpful. And we've got a lot of participants right now. There are 142. And we're not, this is not a city council meeting. It's not a Brown Act meeting, although it is a public meeting and it's being recorded. But we want to hear from as many people as we can. So please, in your remarks, try to be aware that other folks want to share and ask questions too, so that we can hear from everybody or everyone who wants to be heard from. So Ingrid, are you going to moderate in terms of?
I will moderate. Yes, I will moderate, and I already see several hands up. So I will call on you, and I will give you the opportunity to speak. And I'm going to reiterate what Eric said. There's always a debate as to whether or not we should have a clock on the screen. We prefer to keep our workshops a little bit more informal. But I am going to ask that you keep your comments brief and try not to repeat. I want each of you to obviously share what you need to say and share stories or share thoughts. But again, we also have a lot of people that want to participate, and so I think that's really important. And what I'll do is, if some speakers are going very long, I might interrupt and ask that we move forward. So with those ground rules in place, we also we don't allow obscenity. We ask that your comments remain as productive as possible, so that we can all have a productive meeting. again, a little more informal than our city council in terms of decorum, but really hoping that we all can stay positive and share our thoughts. So with that, I have probably about 10 or 12 hands raised right now, but others are welcome to raise their hand as needed. The first person on my list is Pam Daniels. Pam, I'm going to allow you to talk. You may unmute and speak.
My question is very short. Eric referred a couple of times to a requirement or a limitation, something related to, I think it was like waste, something about waste. I'm not generating waste, something that would have an impact on whether a tenant, the impact on the tenant. Could you please clarify what that means? Thank you.
Sure. Thanks for your question. So waste is one of those terms of art. It's a defined term in the law, in the excuse me, in the landlord tenant law, and it refers to actions by a party, and the tenant in this case, that diminishes the property value. So some kind of damage or harm to the property. So that's what waste means. It's not like solid waste or recyclables or that kind of, it's actions that cause damage to or diminish the value of the property. And they're recognized in the Tenant Protection Act as a lawful reason to terminate a rental agreement.
Thank you. That's a good question. I had the same question, so thank you. Gino Medeiros, I'm going to allow you to speak now. Go ahead, Gino.
It made me unmute. Can you hear me?
Yep.
Yeah.
So as a prospective landlord in all of this, I have a couple questions around what our rights and responsibilities are. And one of the things that concerns me is reason for eviction. And I'm not real clear, like this, why would I have to pay someone if I just want to move back into my house? Like that really bothers me as a landlord. Like, why am I going to have to pay somebody to leave when I rented my house to them and now I want to move back into it?
So that's a policy issue that's addressed in the city's regulations. And there's different ways to approach it. The rationale behind the city's regulation is I mean, the purpose, the council's direction to us to bring those to them was to promote housing stability in Petaluma. And the idea behind having to requiring landlords to provide relocation assistance when they terminate a rental agreement when the tenant was not at fault, didn't cause the termination, didn't violate their obligations, is to provide for stability of housing for tenancies. And you saw, I think, that there was a number of different items of feedback that we received about with respect to landlords' rights and whether they ought to be able to let rental agreements expire without having to issue a notice of termination, without being responsible for paying relocation rights, relocation assistance. And so that's the issue. And it sounds like you have that issue too.
Well, actually, we don't have that issue yet, but I'm sort of trying to foresee. And I'm all for tenants' rights, and I was a tenant for many, many years. One of the things that I'm not seeing as I read through all of this, and we live in Pengrove, so we have large agricultural type lots. And our main lot, where our main home is connected to the lot where we have 3 rental units. And we do not want any cultivation of cannabis products, not even for medicinal uses. How do we get around service animals? How do we get around, like, not get around, but how do we deal with service animals? I can't have a pit bull here. My insurance won't allow it. If somebody, I can't handle the smell of marijuana. I live right next door. I don't want even one cannabis plant. I don't care if you have a permit.
So Gino, one main thing is, it sounds like your property's outside the city limits.
It is.
So these regulations do not apply to you.
So
The
then we would be
the
Sonoma
cities
County
do
at
not.
large.
The cities do not apply to you, but the Tenant Protection Act does, because that's state law.
And that's where I get confused because, excuse
So-
me, I get confused because those of us that live in Pengrove or you know, west side of Petaluma, that's outside of the city limits, and we fall into Sonoma County's purview.
Right.
Yeah.
Yeah,
That
but these
affects a lot of
the
us.
city's regulations don't, there's
So
no.
I have to pay city taxes, so how do I not? So basically what I'm hearing, which is great, is the city's rules do not apply to Pengrove residents.
And they don't apply to anyone outside of the city of Petaluma.
Right. Our police power at the basis of the city's regulations is limited to the city's corporate boundaries. And there's only rare exceptions where someone is outside the city's boundaries, but relying on our water or sewer, where they might still be subject to some of our rules. So I want to make sure we get to some other people with commissions, but
Agreed.
for your
Okay, thank
purposes,
you.
these regulations won't apply.
I don't
Thank
even
you,
need to be in
Gino.
this meeting anymore. Thank you very much.
Thank you, Gino.
Good night.
Okay, the next person I'm going to allow to speak is Aiden Smith. Aiden, go ahead and unmute and go ahead. You can go, Aiden.
Hello.
We're not hearing you. Oh, there you are. Okay.
Yes, sorry. Hey, thank you for the time to speak. And I want to say, I think you guys did a good job modifying the state's regulations to be a little bit more tenant friendly. So I'm a tenant. I live in the city. I'm also a member of the tenants union, but I have a couple of thoughts that I wanted to share with you guys. And we just had that chat about relocation just now, and everyone made good points. The landlord made great points, but I want to kind of say out loud that relocation fee is not paying the tenant. That relocation fee is is not accepting 1 month's rent. Like, you're not paying out of your own wallet. You're basically just giving money the tenant gave you back for that 1 month where they have to move and shuffle things and shuffle their life. So on that note, I don't think that the 50% relocation is excessive. Relocating is really hard. Rents are fluctuating like crazy. There's a housing shortage in most parts of the country. Like, relocating is hard. If you're pulling somebody's stable house from underneath them, like, can you imagine the panic that is going to ensue, knowing that, oh, this place that I've lived and I've called my home for however many years is no longer mine and I can't do anything about it? That's tough. That's a tough thing to do. So on that note, the idea of notices being a burden, an excessive burden on landlords, I think that we shouldn't consider that. As if you are a landlord, you have my email, you can email me a document. And if we don't require landlords to do that, the tenants have very few ways to know about their rights. You know, we require all workplaces to post the OSHA rules, because how else will a worker know? You know, it's the same logic that applies here. And then the last kind of thing is on renewing the regulations. You know, I just want everyone to kind of accept that, you know, the party that has the power is always going to be the landlords when we talk about these situations. Everything that we as a government and as a society do to protect the tenant is just offsetting that unbalance a little bit. They own the house. They can pull it from the market. They can raise your rent. They can push you out. You only have the regulations that we as a society create to protect you. That's it. That's all you get. So I think that we need to keep these regulations. Tenants deserve rights. Tenants deserve to feel safe. That's it. Thank you guys for the time.
Thank you, Aiden. The next person is Brittany. Brittany, I'm going to bring you into the meeting. You may unmute and speak.
Hi there, can you hear me?
Yes.
Yeah.
Perfect. I'm a landlord who lives inside of the rental property. And I was curious, I did say on the slides that a live-in owner does not have to be applicable to the Petaluma laws, right? But they are the Tenant Protection Act still is in play. Is that correct? And if so, does the relocation piece of that also apply to me?
Dylan, do you want to field that
I
one?
can handle that one, Eric. Yeah,
Thank you.
sure. So if you are a tenant under our ordinance or a landlord property owner that shares either a bathroom or a kitchen with your tenants, then the ordinance does not apply to you. You wouldn't need to pay any relocation fees for the no at fault evictions. Under the TPA, I believe that's the same thing. So I think you're okay if you share a bathroom with or a kitchen with your tenants.
Okay, thank you so much for your help. Have a great night.
You too.
Okay, thank you, Brittany. Let's move now to Pamela Granger. Pam, you are now going to be invited into the meeting, I think. Pam, are you here? Does that work? Uh-oh. I didn't do the wrong thing. I'm going to move to Sarah Vetter, and then we'll see what happens to Pam.
You already unmuted me. This is Sarah Vetter.
Okay, Sarah, I think Pam, I'll get to you next. I think I moved you instead of unmuted you.
Okay.
Hi, Sarah.
Hi. Yeah, thank you. I have two just kind of clarifying questions. Number one is, can you expand a little bit on a breach of the lease agreement? Because I have like the conduct, is it the conduct portion of the lease, which seems the more like intense or bigger breaches of a lease agreement? Because there's rules in lease agreements that don't feel like the spirit of this ordinance, if that makes sense. Like lease agreements have rules regarding, you know, when to put your trash out and all kinds of things. So is that, yeah, so just a little clarification on what that means. What does breach of lease mean to you?
So, well, it's what's key is what it means under these laws.
Yeah.
Ingrid, could you go back to slide 13 and share that briefly, please? And it sounds like you're asking about at fault kinds of terminations.
Yes,
based on
yeah,
options.
yeah.
So
This one?
I think it's slide 13. We're not seeing it yet. It's
this one?
Actually, why don't you do 14? It's not, you're not, there we go. I think you're sharing now.
Is it this one?
Why don't you go forward to one more to 14 because it's the comparative one. Perfect. Thanks, Ingrid. So what this slide shows is those squares, those colored squares are lawful grounds for terminating tenancies based on the tenant's fault under the Tenant Protection Act. So these are the ones. It's not an open-ended list. Failure to pay rent, using the unit for illegal purposes, breach of, but it's got to be a material breach.
Okay.
So not just, you know, not a minor non-compliance. And then what this slide also shows is how the city regulations reduce the number of grounds for terminating based on tenant fault. It eliminates those 4: waste, failing to vacate after giving notice of intent to vacate, failing to vacate after termination, and subletting when it's prohibited. So
what about Eric? I'm just going to interrupt.
Eric, could I?
Go ahead.
Sure. Go ahead, Dylan.
I'll just add to material breach. It's in the civil code. I don't believe there's a definition, just because it's kind of an ambiguous, amorphous term, but it is in the civil code section, I think 1161 paragraph 3, that says what a material breach is. And I think the ordinance is designed that way because there's so many different facts scenarios that could determine a material breach.
Right. But the key,
so it is
factor,
defined in the law, case law.
Yes, and so you know, it's going to be a little fact specific, but the key is not trivial non-compliance.
Yeah. Okay. That's what it feels like, but thank you for explaining that.
Sure.
And then my second part of the question is, if we are struggling, so both as a landlord and someone who receives a lot of clients who have a lot of questions regarding their tenancy, where should I, like if we're struggling in a situation, will the city support us in explaining which way to, like, who do we go to if we're concerned?
I think I'd like to start with Elise. Elise, are you comfortable responding to that?
Right. I think the best place for anybody, landlord or tenant, to start is with Petaluma People Services Center. And our team will be able to explain it. And if it needs to get elevated, we can make referrals to legal support systems. We can get referrals back to the city and ask additional questions, but suggest that you start with us. And I'll make sure that we put in the information. It's fair housing at petalumapeople.org, and our phone number is 707-765-8488.
Great. Thank you so much, Elise, and thank you for explaining.
Thank you, Sarah. I am going to jump to the next person. Yes, Erin?
And I'll just say that so that people don't feel like they need to write down what Elise said, we can post in the chat the link to the residential tenancy protections city's webpage, which has resources for Petaluma People Services, legal aid, as well as the city's email.
I don't think we have chat. Do we? I don't believe we have chat in a webinar.
Well, we will add it at the end. We'll have the, you'll pull up the last slide and below the email address that we have, we can add the URL and people can, and it would be great if people also knew that on that webpage, they can add their email address. There's a email sign up form, and we can keep you updated when, like a reminder when the March 6th City Council meeting is coming up, if you'd like to attend that, and keep you updated as this progresses. So we'll add that URL to the final slide when we wrap things up, just so you all have that.
Thanks, Erin.
Thank you. That was great. You know, there's a lot of information here, and I think we recognize there's a lot to absorb. So if you have more questions after this meeting, you can refer to our website, and you can reach out. We have a dedicated email. We'll be having a workshop again this Saturday, and then again a follow-up with the City Council. So thank you. I'm going to move next to Pam Granger. I had tried to allow you to talk and I didn't. So Pam, I'm going to call on you now. Hi, Pam.
Hello, that worked. Thank you so much. This is a pretty basic question to everybody but me, apparently. Most of the dialogue has been around those tenants and landlords with lease arrangements. Is there anything that protects a tenant where a first year lease has ended and it's rolled over month to month?
So yes, if that tenant, that's called a periodic tenancy. A lot of residential leases are written such that there's a 12-month initial term, and at the end of the 12 months, the lease automatically converts to a monthly automatically renewing periodic tenancy, where either the landlord or the tenant can give 30 days notice of termination as specified in the lease. That's pretty common. And both the Tenant Protection Act protections and the city's protections apply to that situation, because that's a tenancy, and it's a kind of lease. What it raises, Pam, is that issue that we talked about potentially, at least, on how the expiration of the lease is treated, whether it's treated as something that triggers relocation assistance or not. But to give an example, so if there's a tenancy that converts to a periodic tenancy at the end of the first 12 months, and so it's in the renewing 30-day rental periods, and the landlord wants to terminate the tenancy, they're going to be limited to the lawful grounds for doing that, both at fault and not at fault, both under the Tenant Protection Act and under the city's regulations. unless it's addressed differently, either in our regulations or the lease. For example, some leases might be written so that they don't convert at the end and they just expire.
I see. So a valid lease meeting the requirements of now a month to month, meeting the requirements of the initial lease receives, I'm trying to say it so it doesn't sound dopey. I've got a friend who then would know that as long as there isn't a need for an owner to occupy, and I forget just now, there were one or two other cases where it's okay for the property to be taken off the market,
right,
as long as she maintains the requirements of the lease.
Yep. So, I mean, the easy way to say it, I think, Pam, is that our protections will apply in that situation. So the stuff that we just reviewed,
Yes.
it will apply.
Okay. All right. Thank you so much. Appreciate it.
Sure. Thank you.
Thank you. Okay. All right. Next is Tina. Tina, I'm going to invite you into the meeting and
thank you.
give Tina, you here?
Yeah.
Okay.
Yes, I
Yeah.
am. Okay, thanks. So just want to say thank you so much for this ordinance, and thank you very much for what you're doing for tenants' rights. I really appreciate that. And please do not let the ordinance expire. I cannot attend Saturdays, so how do I go about getting a survey?
If you go to cityofpetaluma.org/tenant protections, there's a form where you can provide your name and your email.
Great.
And when the survey is ready, we will email it out.
Great, thank you. And then also, if I know that landlords can charge deposits for pets, can they also charge rent for pets, like a cat? Can they charge rent for a cat? I know.
That's something that may need to be researched, and maybe our colleagues at Legal Aid know the answer. I mean, pets can't be tenants in the sense that they can't enter into contracts,
right?
And can't be enforced against them, but fees can be charged for different kinds of use. So I don't know, that might depend on whether or not that's presented as a lawful.
Okay, and how do I check that out more thoroughly, would you suggest?
I would, that's a question for actual legal advice.
Oh, okay, got it.
We're not here to provide, but so if
got it, thank you.
Private counsel could, or
yeah. Okay, and then my last question is, I know that there is rent control, and rent can go up to a certain percentage, and then in addition to that, it can go up another percentage. And I'm trying to remember, I read this a while back. I'm trying to remember what it was based on, but I think it was based, very loosely, and paraphrasing, on the current market rates. Is that right? And if so, how do we find out what those are?
We were just reviewing that to get ready for tonight. Dylan, do you have the summary handy that you can share? It's based on the consumer price index for our area.
The CPI. Okay. Okay, so if I look up the CPI, okay, I'm sorry, go ahead.
It's yeah, and I believe, Tina, and again, just to reiterate to everyone, our ordinance doesn't touch the rent control portions of the state law, so that goes by default. But it's 5% plus CPI, and I believe there's a cap at 10%.
Okay, total, not 10% on CPI, but 10% total.
Right, and if I remember right, there are 2 adjustments that are permitted in a year's time, but that's the maximum with respect to both of those adjustments. So you can't double up.
Okay.
That's the maximum for the year, whether it's done one time or in 2 bites.
Okay, great. And this is very informative. I really appreciate you doing this for us. And thanks again for all the service that you're providing for everybody and the protections. Thanks.
Thank you.
Thank you, Tina. Okay, the next person I am going to call on is Riva Novi. Riva, you can unmute and speak. Thank you. Reva, are you there? I don't think we're hearing you.
Can you hear me?
Yes.
Can you hear? Okay.
Yes, thank you.
Okay, actually, it's my husband and I, and we have a couple questions. So if I understand this correctly, if I have a tenant and the lease is expiring, and I've given the tenant adequate notice that I'm not going to be offering a new lease, but the tenant has been an absolutely okay tenant, am I obligated to give them a subsequent lease? That's one question. And the other question is, my intent would be to be moving back into my property. I'm a senior citizen. My husband is a senior citizen. We might need to relocate before 3 years from that point to live near one of our adult children. Am I in violation of this ordinance then?
So there's no requirement to offer the tenant a new lease. But if you're terminating not for fault of the tenant, you may still have to pay the relocation assistance. And that's one of the discussions that we'll have with the city council. And one of the things we've received feedback about. And there's the Ellis, if the landlord is opting to take the property off the market because they want to move in themselves, then that's going to trigger the Ellis Act implementation that we talked about earlier. By the way, Ingrid, are we going to be sharing the full slide deck with folks on our website if they want?
Yes, we can post it to the website.
I already read everything on the website.
Okay.
But I'm not sure if this slide deck that we just shared is on there. So that gives you a summary of the things I'm referring to. And Dylan, anything to add to that answer?
No.
Yeah, so I do think the Ellis Act might not apply. You might be able to use the owner move back in, no fault, just cause. And there it does require you to say that you're going to live there for a year. But if you decide to move out earlier, then you need to offer the tenant that was left the right of first refusal to come back in. Just want to add that besides relocation.
This is Reva's husband, Scott. A question on that. If we do move in, as you've just described, move back in, but it turns out that we wish to subsequently sell the property, and it's in less than a year after we've moved back in, are we allowed to sell the property, or does this ordinance prohibit that and require that we offer the property back to the tenant that left?
You could sell the property, but it'll be subject to the city's regulations the way it's written right now. So,
and what does that mean? Yeah.
So that means that the new owner would have the same, would step into the same obligations you had in terms of offering a right to return to the former tenant.
But if the new owner is going to live in the house as their primary home, then they don't have to offer it to the former tenant. Is that correct?
I believe that's right, because it is, if it's vacant, then you would need to offer it. So
okay, so
that sounds right to me. Yeah.
But if I'm marketing my house, I might not be living in it when I'm marketing it because I want it to look pristine. My house, in order to put it on the market, needs some major work that our tenant is aware of. And that kind of work is not conducive to have somebody living in the house. But when the work would be done, we would move back into the house. But in essence, we would be putting the house on the market. We would probably want the house mostly vacant so that it's the most saleable and in the most pristine condition. I don't understand why these rules are being implemented now instead of at a point when the rules should start, so that people that are current landlords, and this is the only time we've had this property as a rental, we went back east to experiment essentially with living near an adult child. So we're caught in a catch-22 here. We have wonderful tenants. but we're probably going to put the house on the market, but we're going to move back into the house for a period of months while that work's being done, and then we want to put the house on the market. So how does this affect us?
Well, so that situation is
indeed
a pretty detailed one that I'm not sure we can fully answer in our conversation tonight. I think if you terminated the tenancy to move in yourselves,
yes,
and to rehab the property as part of that,
mm-hmm.
I think that would be treated as your tenancy. And if the regulations continue in effect as they are now, your sale would be subject to the regulations. So, and it would depend on whether you were it was vacant at the time or not, and when that's happening in relation to the right to return of the tenant that was terminated, and whether they chose to exercise their right, because they may not choose to, and they have to provide their forwarding address so that you can give them that notice. So there's a number of details there, but some important takeaways I think are currently sale of a property. It doesn't make the regulation, the city's regulations, inapplicable to that property. So you need to consider like what the situation is in terms of the tenancy at the time of sale. Dylan, were you going to add something?
We would be living.
No, I think that's right.
Okay, so I hope that beyond that, I mean, you're asking some pretty specific questions, and that's fine. But if you're going to make some actual financial decisions, you know, that's the time when you may want to be consulting with private legal counsel, whose job it is to give you very clear answers that are you can rely upon in terms of making your financial decision in your situation.
Thank you. I have one more question, and it's something I might not have heard clearly. Did I hear that leases need to be provided in both English and in Spanish, even if both the landlord, that's us, and our tenants have English as their first language? Do we still need to provide them a Spanish language copy?
No, you need to give the notices that our regulations require in English and Spanish. And we have provided those already, and they're on our website. So it's not going to be at any cost to landlords.
And so we would just access the proper notification form.
Right.
Yeah.
We wanted to make that easy. We didn't want to add cost or burden for landlords, and we wanted the information to be uniform and that we knew it would be accurate for landlords and tenants. So that's why we've provided those notices.
Great. Okay, that makes sense. Thank you. Thank you very much.
Thank you, Reba and Scott. Okay, the next speaker I have is Daisy Lopez. I'm sorry if I mispronounced your name. I'm going to allow you into the meeting. You may unmute and speak now.
Hola, buenas tardes. Mi nombre es Daisy López. Soy una inquilina en Petaluma y una miembro de la Unión de Inquilinos del Condado de Sonoma. Estoy aquí para pedir a la ciudad de Petaluma para pasar una versión más fuerte de la ordenanza para proteger a los inquilinos como yo.
Daisy, voy a traducir lo que está diciendo. Voy a pedir si Cristina nos puede ayudar.
Ok, claro, sí.
Gracias. No.
I think, is Jameson going to move one of our interpreters back to this group, and then they can speak, translate on her behalf? Is that, I think, what Christina might be pointing to?
Sorry, I'm not sure what the issue is.
So one of the translators needs to be removed as a translator so she can come back into our room and speak in English.
I see.
No,
No?
let me go into the Spanish room.
Okay.
Hi, yeah. Okay, I wasn't hearing you. That was the only thing. Okay, I'm going to choose English right now, and I'm going to ask everyone on the panel and anyone who's listening that wants to hear the translation, do that now. Okay, Christina, I'm in the English channel and I'm not hearing you though. Yes, yes. Got it. So could you then just translate what you heard Daisy say, and then we'll let her continue.
So Ingrid, we're not hearing the translation in the English channel.
Is Jameson supposed to update something for her?
I don't see anything.
So all of you who are in the regular meeting session, you need to go to the little globe at the bottom and choose English instead of
original audio.
Instead of original audio, yes.
Okay.
Okay, so Christina, can you let Daisy know that she can continue asking her question or offering her feedback? Yep. Thank you.
Thank you.
I think Daisy needs to go into the Spanish room. Or to the Spanish channel, because Christina is speaking to her on the Spanish channel, I think.
Can you translate the question though, or the comment?
A ver
Laura?
si Daisy, ¿estás todavía aquí? ¿Está...
Sí.
¿Me puede oír?
Sí.
Si necesita, Christina, should I have her go back into the Spanish channel? Daisy, por favor, si puedes entrar al cuarto de español, debajo donde tiene interpretación, el globo, si puedes escoger español otra vez, Cristina le puede ayudar, le puede oír y traducir para nosotros en inglés.
Okay. ¿Me escucha, Cristina? Sí, ya lo escucho. Okay. Sí, claro. Sí, claro. Buenas noches. Mi nombre es Daisy López. Soy una inquilina en Petaluma y una miembro de la Unión de Inquilinos del Condado de Sonoma. Estoy aquí para pedir a la ciudad de Petaluma pasar una versión más fuerte de la ordenanza para proteger a los inquilinos como yo. Ok. Específicamente, la número 1 sería ordenanza debe ser permanente. 2, las protecciones deben cubrir las unidades subvencionadas y todas las unidades de alquiler. 3, necesitamos que estas protecciones comiencen inmediatamente tras la aprobación de la ordenanza, eliminando la espera de 6 meses. 4, deben aumentarnos los pagos de realojamiento para que se ajusten al costo real de la mudanza y recompensar a los inquilinos que son desalojados por causas ajenas a su voluntad. Y en cantidad de referencia para realojamiento debe ajustarse a la inflación de cada año. En la actualidad, los propietarios suelen aplicar el pago de un mes por traslado al último mes de alquiler y a veces también es una lucha recuperar la fianza. B. La mayoría. ¿Sí? Sí, claro. Sí. Sí, claro, sí. ¿Quiere que la repita? Sí, dice, deben aumentarse los pagos de realojamiento para que se ajusten al costo real de la mudanza y recompensen a los inquilinos que son desalojados por causas ajenas a su voluntad. Y esta cantidad de referencia para desalojamiento debe ajustarse a la inflación cada año. En la actualidad, los propietarios suelen aplicar el pago de un mes por traslado al último mes de alquiler y a veces también es una lucha recuperar la fianza. La mayoría de los inquilinos necesitan al menos la mitad de un pago directo en el momento de la notificación del aviso para cubrir los gastos de mudanza que se acumulan antes del día que se mudan. Gracias por su tiempo y consideración.
Gracias, Stacy.
Gracias a usted.
Okay, the next person I have is Houston. Houston, I'm going to allow you in the meeting room. You may now unmute and speak.
Thank you very much. I have a couple of questions. One of the initial slides said that the Petaluma ordinance does not affect leases. The provision, I assume that means provisions within the lease, but then it goes on to say that one of the subletting against the lease is no longer a reason for eviction. That sounds like that does affect the lease. That's in most leases. A landlord does want to be able to control who is in the property. And so that's normally in there. Same with, and I also, so I'm curious about that, how that's not affecting the lease. And also, I'm curious of the logic behind, or the reasoning behind eliminating the committing waste as a reason for eviction. If a tenant is committing waste, I don't understand who it helps to not allow the landlord to evict.
So, so what those initial slides were trying to point out is that the city's regulations, and for that matter, the Tenant Protection Act, don't amend leases other than to limit the lawful grounds for terminating the leases. And the rationale, I believe, for the elimination of the waste grounds is because it can be ambiguous. And I think there are arguments that it's been abused in some cases by landlords as a pretext for terminating a rental agreement. So, and I'm not trying to advocate, we're really here to just have a conversation and hear everyone's perspective and carry those thoughts forward to the council, but that's how I would answer your questions.
Okay, it's not really, I appreciate that, but the committing waste is the cost of construction to clean up after a tenant has committed waste has gone up astronomically. I represent a lot of landlords, and that is something, landlords can no longer charge an amount for deposit that comes even close to covering a lot of these costs. So although any provision can be taken advantage of and can be used inappropriately, that one seems to eliminate a landlord's right to evict a tenant for committing waste because some people may have abused it, seems to lean very heavily on the landlord. That's a major reason to, I mean, if your property is being destroyed, to not be allowed to evict somebody, I'm not sure where the logic is in that.
Well, to the extent, you know, I shared it with you, and you probably saw in some of the feedback that we listed in the slides at the end of our presentation, that the one you're raising, we've heard that one too, you know, that waste should be recognized as a lawful grounds for terminating a rental agreement. So it sounds like you're echoing that sentiment, and that's fine. That's what we're here to hear. And
okay.
And Eric, I can add too. I think you didn't see where the Tenant Protection Act had specific provisions for issuing just cause for waste, the sublease. That's not included in your ordinance, like you said, Houston. But I think you'd be able to go evict under the breach of your material lease. I think that's how you would get around it, is if the subletting, if that's a material term in your lease as well as the waste, you'd be able to evict through the breach.
Okay, well, the material term is fairly ambiguous, and it's not usually, I would find it hard to believe that would be up to the landlord to get to decide what that is. So taking that out means that it will not be up to the landlord to say, I feel that subletting against the lease is a material breach, especially since that's being eliminated. But okay, I mean, this is clearly, it's very tenant leaning. It's California, I get it. It leans towards tenants. I do have a question for Elise. Elise, you'd mentioned that people can call in and get references to legal support systems. Are there any for landlords?
Yes, and our team can make those referrals, and our team will also walk you through any questions you might have that are not legal in nature, or give you additional information that you may need when you consider that. And as part of our commitment, whatever we decide with this ordinance, we will also do landlord training and continue to do landlord training.
Okay, because I think everybody just makes this assumption landlords are the rich ones with the money. I have a lot of clients who, I mean, great example, teacher saved up all of her money. She did not invest in Tesla stock. She invested in a piece of property to have it as a rental, to make that available, and is now seeing such restrictions on her rights as a landlord. She's decided to pull that from the market. She also doesn't have the funds to go and hire a real estate attorney to figure out what the rules are and what she can and can't do. Whereas there seems to be, and you just mentioned, as long as it's not a legal question, but there's a lot of resources for tenants where they do get legal advice. I've had landlords who had to deal with tenants that were able to get around the system by getting a lot of legal help that they didn't have to pay for that isn't available to landlords. So, all right, well, thank you very much. I just do want to let you know, we have a lot of clients who are landlords, and quite a few of them have decided to pull their properties from the market. You know, I remember doing a paper in college in the 90s that rent control causes homelessness, and we're seeing that. I mean, the more and more restrictions, the less investors are going to want to be involved in it. They're moving to other states where they have more rights over their property.
So Houston, when we had stakeholder meetings earlier with landlord groups and also tenant protection advocates, we invited them to provide factual information for us to share with the council when we come back for the workshop. And I'll mention that again to everybody attending this webinar. So if you'd like to share specifics, like, you know, we had this many clients and it's been reduced by this many in response to city's regulations, those are things the council is interested in hearing. So
okay, thank you.
Feel free to forward that using the web contact information that our team is sharing.
All right, thank you so
cityofpetaluma.org/tenant protections, or you can email us at tenantprotections@cityofpetaluma.org. Wait, Aaron, it's landlord. Can you say that? Can you remind me?
We have two emails, but the shortest one is tenantprotections@cityofpetaluma.org. There's also landlord tenant protections at cityofpetaluma.org.
And I'll show these again before we end the meeting. Thank you, Houston.
Thank you.
All right, I am going to go to the next person, which is Clayton. Also, just to let you know, it seems like I still have a dozen or so names. We're gonna continue this meeting until 8 o'clock. If for some reason I don't call on you and you continue to have questions, we'll let you know how to follow up with one of us with additional questions. So Clayton, I'm going to go ahead and I've let you in the meeting. You can unmute and speak now.
Thank you all for having this meeting. I've read the ordinance several times over the last few days, and I cannot imagine why a landlord would buy an investment property with this ordinance in place. Everything in the ordinance is talking about civil litigation. They talk about the minimum that a landlord has to pay to get rid of a tenant, but they don't talk about the maximum. And your ordinance talks about how the maximum could be anything that the landlord and the tenant kind of agree to outside of this. So I think it's horribly leaning toward the tenant. Some of the things you talked about with waste. I sold my property a year and a half ago on Jess Avenue, 58 Jess Avenue. I regularly got a notice from the city of Petaluma about the clutter that my tenant was accumulating at the property. Disabled Vietnam vet, horrible health conditions, in a wheelchair. He was my charity case. I allowed him to be in there, and this guy absolutely destroyed the property. He garbaged it up like you've never seen. I was constantly getting, every year I got a letter from the city. Guess what? They came after the landlord. They didn't go after the tenant. They came after the landlord for waste. The last letter I gave him, he paid the $100 fine, and he never paid me another $1 in rent. I ended up selling the house. I could not get him out. He would not allow the property to be shown. I took $100,000 hit on the property. You know, I'm not playing woe is me on the thing, but this is exactly the kind of thing that you should be trying to protect or have a balance between the landlord and the tenant. So with regarding waste, your ordinance is horrible. Waste needs to be part of the process. Also, in regards to a tenant subletting a property, you mean to tell me I'm not going to have control of who my tenant sublets to? They're going to go on VRBO and they're going to rent to everybody or anybody and absolutely destroy the neighborhood and all my wonderful neighbors? That's ridiculous. Absolutely ridiculous that your ordinance would allow a sublet of one of my houses with no vetting whatsoever, and the recourse is on the landlord, not ever on the tenant. So if you want to shift the liability to the tenant, power on, but that's not the way your ordinance is written. Also, your ordinance is written with all this recourse and civil violations and punitive violations against the landlord. What landlord on earth would ever put up for that? I have spent the last 40 years being a landlord in Petaluma. I have finally got to the point where, God, I would love to retire. Doesn't it look like your ordinance is going to allow me to retire? And I think the question is, if I establish a lease going in, let's just say it's 16 months, absolute drop dead, get out in 16 months. Am I allowed to do that? Eric, Dylan, Ingrid?
Yes, you're allowed to do that. And then the question is whether tenants at Suffrag's who remain after this expiration 16 months get the ordinance protections or not. Currently, they would. And you are arguing for being able to have a lease expire without having to and have the protections expire with them. And we've heard that from other folks too. And remember, we're not here to debate with folks. We're here to take your input, which we're glad to do. And registering what you're raising. One of the things we've heard from a number of folks is the idea in different kinds of contexts, whether it's the activation to active duty or sabbatical, or just wanting to be able to have a term lease and have certainty that the obligations cease at that time, and have the landlord being able to choose, and the tenant too, whether they want to re-enter a new lease arrangement or not. That we have received that feedback, and it sounds like you're giving that to us also. So that's we're happy to hear your comments.
Yeah, well, what I'm looking for is an absolute, if there are a hard and fast, I have a job assignment, takes me out of the area and I'm coming back, and that's hard and fast. I don't want to give notice. I want to have that notice up front. Everybody has that understanding on whatever that date may be in the future. It's hard and fast. Get the hell out, because I'm moving in.
So
thank you.
Thank you, Clayton. Thank you. I think that was helpful feedback. I'm gonna lower your hand, and I'm going to now invite, this is a phone number. So the phone number I'm going to invite in is 880-643-41317. 80. Anyways, if you have a phone number that starts with 880, I'm going to open you up into the meeting, and you may unmute and speak.
And thanks, Ingrid. And I just want to remind folks we're getting a little short on time, and so to the extent folks can really focus on their key questions and comments, so that we can hear from as many community members as we can, that would be great. Thank you.
If you're there on a phone that starts with 880, would you like to speak? You can unmute and speak. I'm going to move on because I'm not hearing you, but I'll come back to you. And I'm going to move to Mary Glarden. Mary, I'm going to invite you into the meeting. You may unmute and speak now. Mary, are you there? Oh, hi.
Yes, I am. Thank you so much. I am going to speak from not only a landlord standpoint, but also from a rental standpoint. I think that your ordinance has gone a field too far. You're going to lose your rental market in this city. My family has been in the rental business my entire life, and I'm a landlady as well. And here's our problem. Your ordinance is I understand there's good things to help renters, and I've had charity cases, and I've bent over backward to help the elderly and keep their rents down and everything. But the problem that this ordinance really destroys for the city, and I see it's happening in Fairfax, California too, where droves of mom and pop owners, which is what we are, we have to get out of the business if this goes into place, because I'll tell you what, if you have a situation where you have an X where it says waste, committing waste, and also subletting, then you're killing your landlords. And I'll tell you why. Mom and pop landlords cannot handle this. You will find that the only people that can really handle this will be corporate landlords. And they have bigger lawyers, and it'll take you months and months with these people being put out of their homes. And the reason I say that is, if you as a landlord, we all love our homes. You know, in our businesses, we want to protect not only the homes, but also the neighborhood. And there's no one better to do that than a responsible landlord. But if we don't have the right to stop a tenant from creating waste or stop a tenant from subletting, we don't have the right, we wouldn't have the right with this to stop anybody that was living in our rentals to not be moving in family members that are hoarders, and they'll destroy a home in no time at all. If they're meth heads and they're cooking up meth, and this has happened in the past, I've seen what it costs to deal with that. It's extraordinary. You will kill that market. If you have somebody move in that's got moldy furniture and clothing, and it's easy for your renters to move a beloved family member in that they want to help, that's down on their luck, and I get that. But you're going to destroy that home. You're going to destroy that neighborhood. In Fairfax, people that are mom and pop landlords and landladies are selling their properties because.
So Mary, can I break in there for a second? I'm afraid we still have what, 18 people to hear from, and I'm hearing you say you're concerned about eliminating waste and prohibited subleasing as grounds for termination, and
yes,
that's what we're here to hear. Is there anything else you wanted to add to that?
Well, my question is, one of the things you might want to address is the number of properties that you actually have in the market as rentals. So my final note is, if you end up having to sell your home because it's not a viable investment anymore, also when you go to sell that home, anybody that wants, it would have to be like a private ownership that's not looking to rent it as well, because the rental sale of that property is not going to be what investors are going to be looking for in this particular city. And that's my point.
Okay, thank you.
Thank you, Mary. The next person I'm going to invite in is John Simpson. John Simpson, go ahead and unmute and speak.
Hello, thanks for having us. It's been helpful to listen to some of the questions because it started to answer some of my questions, but I still had a few points. So I just want to clarify, because I'm a potential landlord, termination. Like someone said, if you have a 12-month lease, is termination giving notice that the lease is over and we're moving on, or is termination you need them to leave early?
So it was a little bit hard to hear you, but it sounds like you're asking whether expiration of the lease counts as termination. Is that your question?
Sorry, yeah, I mean, I guess I come from a point of view of I signed a 12-month lease with somebody and the term is up, but.
So as we've mentioned a few times, I know it's not, I think it's a little bit complicated. And one thing I'm going to add is whatever council direction we end up receiving, when we go back to them, we are going to identify some things that we think would be good to clarify, just so the regulations, wherever the council wants them to fall, just so they're clear. And one area that's, I think, a little complicated right now, could use clarification, is whether or not tenants at suffrage or holdover tenants are protected out of the ordinance. And currently they are. Currently they are protected. So that would mean that even after the expiration of the lease term, the landlord, the tenant would still have protections from a notice of termination. And that may be something, a number of people have spoken to say that should be changed, and that may be something the council decides to change, but that's the way it works currently.
So the scenario, if I signed a 12-month lease, I wanted to move back in at the end of that 12 months. I gave notice, whatever 3-4 months notice, I still have to pay the relocation fee.
Yes.
Okay.
Unless you have another grounds for terminating for cause that is doesn't require payment of relocation, some kind of tenant breach.
I guess this would be a feedback point. I think you said if I sell the house, that the new owners are subject to the same rules and protections to
They would be subject to the same tenancy and the same obligations to the tenant that you were subject.
Feedback would be that that is going too far, frankly, and not hurting the value of people's homes that they own. For people aren't going to, they'll be confused and scared off by something like that. I just think that's really going too far to push that to a new owner. It just seems ridiculous. And then the last thing, there seem to be several rules around age, or if they're in school or a teacher, about limiting, when you can move in. Do people have to disclose to you if they fall into one of those categories? Because that's, again, if I come back in 12 months, the 12 months happens to be during the school year, it's November.
Well, most tenancies require the tenant to provide information about their employment and source of income, et cetera. So there will be disclosure about Petaluma teachers under those circumstances, and the leases I'm used to seeing, the residential leases forms I'm used to seeing, include the occupants making up the tenant household, which I think would indicate school-age children too. So I think those were would be the kinds of notice that regarding that.
A little bit back the other direction a little bit is, if we have to abide by those rules, we should know who's going to be subject to those rules when we sign the lease, for sure. Not have to dig through it and try to interpret if they are going to be part of the exclusion. And lastly, I would say, just echo what other folks have said, as a potential tenant or potential landlord, this is like, pushing me away from it. And I think if I had any comment, I think that would cover it, is that the regular state TPA you mentioned has single family homes are excluded or exempt from these things. I think that's the one that's kind of the killer, honestly. These are our homes, these are our investments, these are our livelihood, not our livelihoods. You're messing around with that, and so you're gonna push people away. And so I appreciate you guys having this forum. It's been helpful, and thanks for the time.
Thank you.
Thank you, John. I'm going to now move on to Dave. Dave, I'm going to allow you in the meeting, and you may now speak, unmute and speak.
Hello, can you hear me?
Yes.
Yes.
Oh, great. I would really just kind of echo a lot of what we're hearing from landlords. I have a house that I bought that I lived in for many years here in Petaluma. I bought it as a retirement insurance for myself. The last 5 years I'd been renting it. I had a 1-year lease. that reverted to a month to month. My tenant gave me plenty of notice when she decided to move out, and she moved out, and now the house is empty. No problem, but I can't do the same thing on my side, and that's the way this ordinance is reading. The tenant has the ability to give me a certain notice and move out without any issue, but I can't do the same to the tenant if I need the house for some other use. This is my retirement home. When I, at some point, maybe need to sell it because I need long-term care, this is my insurance policy. It's one house that I own. How am I to protect myself? I can't sell the house. I can't, it would be, normally I would give a normal notice and be fair about it and be able to have the house vacated, spruce it up, paint it up, maybe have somebody stage it so that it has a real nice look on it when it's sold, so that I can get the best price that I can to take care of my long-term health. This ordinance prevents me from doing that. So I'm not addressing this just to you. I know that you didn't write the ordinance, but I think you need to communicate this to and you guys are great. You're being very respectful, and I appreciate what you're doing. But I think somebody needs to speak up for some of these issues, especially with single family dwelling owners, many of us in the same position.
Dave, thank you for your comments. We, as I said, a number of folks are raising the issue about the exemption for folks who only a single property or few properties. We actually did write the ordinance, but it was in response to the council's direction using the model that was provided from legal aid and also is used in Marin. So we're here to hear the comments just like yours. So thanks for sharing your comments with us.
I would like also add one other thing. You know, we make agreements with people all the time. We buy cars, we buy appliances, we go to the bank, we get loans, we make agreements, we make contracts. I offer you something, you give me something in return. We both agree to it. But it seems like this ordinance prohibits us from making a contract with somebody that we can both live up to and both abide by. These are arbitrary. Actually, I think the ordinance is more arbitrary than what the ordinance is trying to prevent. The ordinance is trying to prevent arbitrary, retaliatory, or discriminating evictions. I think it's doing the opposite. It's making it so hard for us to have just a normal relationship with the tenant. I'm not going to go on and on. I think I've made my point, and I thank you for hearing me.
Thank you.
Thank you, Dave. The next person is Diana. Diana, I'm going to invite you into the room now. Thank you, Diana.
Thank you. So I am an organizer with the Sonoma County Tenants Union, and I am actually a little bit puzzled. In the presentation that you gave, you included all of the feedback that you'd gotten from landlords during the landlord stakeholder meeting, but I didn't see any of the feedback that we gave you at the tenant advocate stakeholder meeting. So I'd love to get some clarification on why that seems to be the case. Obviously, we want to have a stronger version of the ordinance to protect tenants. Including things like the ordinance should obviously be permanent. We need to be covering all rental units because there's no reason that someone should be evicted through no fault of their own simply by the arbitrary fact of what kind of housing they live in, whether it's like subsidized housing or what have you. We need these protections to begin immediately. There's no reason for this sort of 6-month waiting period. This ordinance has been in place since September, and so why add another 6 months after passing the ordinance? That seems excessive, and people deserve protections. Nearly all just cause ordinance start at day one, and obviously rehousing payments should be increased as well. We talked about this at length during the stakeholder meeting. So again, maybe I missed it. Correct me if I'm wrong, but the rehousing payments should reflect what it is, at least what's required to move, if not just compensating tenants for being evicted through no fault of their own. This is people's housing. I think the reason that this this ordinance doesn't necessarily map onto some of the other sort of day-to-day agreements is because housing is such a fundamental aspect of life. You can't simply, trade in your rental unit, your apartment for another one easily. It's not that simple. Whereas you can maybe return a car or even something, a big purchase like that. There's ways of kind of getting around that, but you can't, it's hard to really make it without some stable housing. And definitely think that rehousing payments should be tied to inflation. This is just makes sense for any sort of payments. Again, these are people being evicted through no fault of their own. So it's not about, I don't mean to be redundant on that. And then given the fact that so many people struggle to get the sort of the payments that they need in time, we'd ask that at least half of this amount should be given at the time of notice, just to make sure that people are given the proper amount in order to move. But yeah, again, I'd love to hear sort of an explanation for why, so much of the comments and the feedback that has been included and given a lot of credit is only coming from landlords, from what we can tell, and not coming from the tenant side of things. Thank you.
Thank you, Diana. And I'll speak to the website. I know we've been collecting information and uploading. I don't think we're complete with our uploading. So I'll circle back with our team tomorrow and double check to make sure that anything that you either provided in writing or sent us an email gets uploaded.
I think she's talking about the slides that we presented, those are the same slides that you saw, Diana, at our meeting on Thursday. So by no means is that a comprehensive list.
Right. I was so when we went to that meeting, I mean, I think we were all a little bit surprised because we were hoping to workshop it, and then we'd heard, okay, we had this landlord meeting earlier today, and here's all the points that they made, and aren't they good points and things like that. And then, getting that PowerPoint and that being seemingly the exact same PowerPoint presented to the public tonight, which seems to kind of bias the whole process, honestly. I think, I'm sure everyone's well-intentioned, but I think it only makes sense that the feedback that we were able to give during that stakeholder meeting should be included in the PowerPoint presentation as well.
Oh, okay. I don't think, sorry. I don't think, Diana, I was clear on that. You're saying at the list at the end.
Yeah,
and I can answer that.
Talking about community input, but only referring to the community input seemingly given from those stakeholders.
So Diana, that PowerPoint was made before all of the stakeholder presentations from feedback that we heard before those. So we hadn't amended the PowerPoint subsequent to any of those stakeholder meetings. So that's why we didn't change it. I don't know if there's,
Okay, and sorry, was that feedback, because we also know, and this was included in the letter from legal aid, that there were meetings that were happening with landlord lobbyists, that we were not invited to those sort of meetings. Meanwhile, from my understanding, we've been ignored at various times by the city. So it's just, again, it's a bit frustrating. I'm sure you can hear it in my voice, but we just want to make sure that our comments are being heard.
Gotcha, Diana.
They definitely are, Diana, and I would push back about us not hearing one side or the other. So I think that's kind of all I'll say on that. But thank you. Points noted, and we have them. Yeah.
And Diana, feel free to reach out to me in the morning to follow through. Like I said, I think that our goal is to include all the feedback we've received. The ordinance as it is, reflects what was requested, and what we're hearing are things that people do and don't like about it. But definitely happy to follow up. We have not met with anyone privately outside of any of the meetings that we've shared. So just wanted to correct that. That's not the case. But thank you for being here and
2 hours with the tenants.
Yeah, and we're happy to talk to anyone, your group or anyone else at any time when we're available. So please reach out. Thank you so much. I am going to move to the next person, which is Matthew. Matthew, You are in the meeting and you may speak. Matthew? I'm not hearing Matthew. I'm gonna move to the next person. Matthew, if you are able to fix your audio, we'll come back to you. I also wanted to let you all know, we are confirming that we're 7 minutes out until 8 p.m. We are happy to stay longer on this webinar for anyone who wants to continue to share or ask questions. We believe that the webinar, we're confirming, Jameson, I don't know if you can nod if we think that this webinar will continue. Sometimes the webinars will shut off. Is this one will stay on? I can't hear you. I'm sorry, you're muted.
Oh, sorry. We believe that it will continue past 8.
Okay, so our goal is to stay. If for some reason, I'll just put this out there, if for some reason at 8 o'clock this webinar shuts down, which I don't think it will, we're a little bit, believe it or not, we've been doing this for years, but still, we're still working out the bugs on our Zoom. If for some reason it goes away, then, oh, I see Aaron. Aaron, can you help us?
Ingrid, I can confirm that it will not shut off.
Okay, good. Okay, good. Perfect. So we will stay beyond 8 for anyone who chooses to stay beyond 8. Thank you so much. All right. So the next person I'm going to invite is Phil. Phil, you are invited into the meeting to speak. Thank you.
Okay, thank you. I would like to reiterate that I kind of agree with a couple of the past landlord comments. I'm a landlord myself, so I'm not going to go through all of the reasons why. I think everybody's expressed that, but I'm just want to add my voice to that. I think my question is going to be a very short one for you guys. I'm an out-of-state landlord, have been for a long time. The property I have is professionally managed in Petaluma, and it's worked very, very well for me and for my tenants, who is a very long-term tenant. I have the property, though, some years ago, transferred into a LLC. Does that impact anything at all with regards to the way that I bring tenants in or replace tenants, or is there any, do all the laws, rules and regulations that you're stating now actually still apply, whether it's an LLC or whether you're a private landlord?
Phil, we lost our city attorney. He lost his internet connection. Dylan, do you want to jump in?
What was the exact question? I'm sorry.
I think it was something about if he were to, his property in Petaluma is owned by an LLC. Does that have any effect on how these will apply to him?
No. So currently, it doesn't matter how the property is owned. If you're one of the properties that the ordinance applies to, and your tenant has lived there for 6 months or 12 months if it's an ADU unit, the ordinance will apply to you. So it doesn't matter how it's owned. But that is something under the Tenant Protection Act. If it's a single family corporate entity or single family home corporate entity, and you provide notice in your lease that the Tenant Protection Act does not apply to you, that would be an exemption under the Tenant Protection Act, but not currently in the city's ordinance. So thanks for your question, Phil.
Thank you.
All right, so we are going to go to Diane Rowley. Diane, I'm going to invite you. Oh, hold on. Here we go. Oops. All right, Diane, you are in the meeting. You can unmute and speak.
Hi, I just want to say that I'm a landlord and a longtime third-generation Petaluma family member in the agriculture department of this community. And I feel that our city is really going in the wrong direction with this ordinance. And I just want to voice my concern and dislike of all the city taking over this town and going in a wrong direction all the way around? And how many of you own a house and plan to use it for your retirement? Own a rental house in Petaluma.
Diane, we're not able to answer. I'm not able to pose that question to our participants, but did you have a question for us about the ordinance itself?
No, just to voice my disapproval. Thank you.
I understand. Thank you very much. The next person I'm going to invite in is KG. KG, you are in the meeting and you may unmute and speak.
I don't want to waste too much of people's time other than what's already been said by landlords. I think the ordinance should expire. I'm in the process of obtaining a second home and I own my current home in Petaluma in the city limits. And after seeing and reading all of this, I think I'm better off just selling it and cashing out. And, I just think it's going to be hurting a lot of people. I take good pride in my home and respect my neighbors. And I don't think that this is going in the right direction. The one question I do have is, will the city be hiring more staff to be maintaining all of this and regulating it and interrogating owners? I mean, how much more of the general fund is going to be going towards ordinances and regulating this?
I don't know that we can answer that question for you right now, KG, but I definitely register your feedback and we'll take notes. And did you have any questions about the ordinance before we move to another speaker?
No, everything's already been answered. So
thank you very much.
Thank you.
All right, the next person I'm going to invite in is Tenant Page D. I'm going to allow you to speak. You're in the meeting. You may unmute and speak now.
Hello, good evening. Can you hear me?
Yes.
Wonderful. And I noticed I was called right at 8 p.m. So it looks like our webinar was not cut off, which is—
We're still here. Yay.
wonderful.
Thank you.
Really
Thank you, everyone.
Would you have an update of how many folks are still in attendance? I think I heard like 140 early on.
We still have 86 attendees and 11 hands raised.
Wonderful. Thank you so much for the opportunity to speak tonight. I wanted to identify myself. My name is Paige D, and I am currently a tenant in Petaluma District 6. Wanted to thank staff for holding this webinar. I saw that the outreach calendar looked pretty tight, and I'm really thrilled that we got a chance to be here and ask questions and provide feedback in real time. I also took a really close look at the website, and I thought that the landlords page especially was really clear for what was going to be required of them during this time. So thank you. My feedback on the ordinance tonight includes the following. The ordinance must continue. The housing crisis in Petaluma will not be resolved on July 1. The purpose of the ordinance from the text itself is to provide housing stability through adoption of local protections against arbitrary evictions and to increase certainty and fairness in the residential rental market within the city. I wish it could be true, but this will not be achieved between the period of October 17th through June 30th. Next piece of feedback, and staff who've been working on this already know that the TPA has a lot of loopholes. They're fairly easy to find, and I would say exploit as well. I am deeply aware of the loopholes because I fell into them as a Petaluma tenant here in 2022. This ordinance reduces the amount of exemptions that are present in the TPA. I think that this is crucial for our community. There are a lot of renters here that live in single family homes, and I think that this provision needs to continue within the ordinance. I would also encourage City Council to remove subsidized government units from the list of exemptions in our city in order to maximize protections for vulnerable renters. In my case, I signed a multi-year lease and there was no fault on the tenant's end. However, the TPA didn't cover me because I had signed my lease just 4 months ago when the landlord decided to sell. So Petaluma's ordinance needs to protect tenants on day one. And this has to be regardless of where the landlord lives, whether the landlord is on the same property as me or not. I need protections against them changing their minds in order to have a stable housing experience within the city limits. These protections simply clarify what happens when a landlord wants to break the lease. In the cases that we heard tonight, these landlords seem to want to break the lease for their own financial benefit, whether that was to sell for retirement, move in for improvements, or things like that. In my experience, the Ellis Act shifts the cost of the burden of the change, shifts the cost to the landlords. And I think that this is not a radical idea because the landlords stand to benefit from the move-in or the sale. I also suggest that the relocation assistance is increased to higher than 100% of 1 month's rent. I think it needs to be 120 days of rent. This is the same amount of time that tenants would be noticed in advance of the move-out date when it is a no-fault eviction. In 2022, before this ordinance went into effect, unfortunately about 3 weeks before the ordinance went into effect, I was compelled to self-evict so my landlord could sell their property with more favorable terms. At that time, I needed 3.2 months rent in cash for the new landlord, while my current landlord was also holding 1 month's rent. So that was $10,200 in cash that I needed to give to my landlords. And that was just for the privilege of also paying them rent for the month. Where there are inequities, such as between the power imbalance, such as between tenants and landlords, we rely on local government to set the floor and set the standards of the bare minimum of how we care for each other. In this case, when landlords seek to break the lease or to break the terms that they set out for their tenants, I really appreciate that this ordinance advocates and protects tenants. And I really appreciate your time and openness to this feedback. Thank you.
Thank you, Paige. Okay, the next person I have on the list is Nicole Marzo. Nicole, you may unmute.
Hi, thank you for putting this on. I'm going to try to be quick. I just had a couple of comments with the waste that you can't evict somebody for waste, and that the sublet, you can't evict somebody for subletting. I posed the question, is this ordinance creating a health and safety issue based on those two things, just as maybe a different way to think about it? And then my other thing is, if a property owner and a renter enter into an agreement for, say, a year, and everybody honors that agreement, and then the property owner cannot renew it for whatever their reasons are, I don't think that should be, the property owner should be faulted for that, right? Like, things come up in life. That was an agreement that both parties entered into. So I kind of feel like this ordinance maybe is short-sighted in that regard. The other thing I just ask, and you probably can't answer this right now, is how many move-outs did we have in the city of Petaluma last year? And how many were tenant-driven, like they gave notice to the landlord? And then how many were evictions? Like what were the percentages, if you know? I don't know. That's it. I wouldn't want you to create this ordinance and then create other problems too, right? It's not a perfect world. Thank you.
Thank you, Nicole. The next person I have is Sunny. Sunny, I'm going to invite you into the meeting. You may unmute and speak now.
Good evening, panel. Thank you for holding this meeting and thank you for giving me the time to speak. I'll be very brief. I am a tenant in Petaluma. I'm also an attorney at Legal Aid of Sonoma County. I have been a tenant for my entire adult life, and I can say with certainty that these protections are very needed to create a less inequitable playing field for tenants. I also just want to address I haven't been on all night, but for I think about 45 minutes I've been on, I've heard several landlords raise the issue of the waste provision. And I will just say, to be crystal clear, that the waste provision is not included because every example that's been given by landlords tonight would be permitted to go forward under the ordinance, under nuisance, or another provision under the breach of lease. And so every example that every landlord gave that I've listened to would be allowed to go forward under the existing ordinance. And the waste was just redundant of existing protections. It was writing in language that was in excess of the state protections. So every example given would have been permitted as cause under the Tenant Protection Act under Petaluma's existing ordinance. I will also say that to the extent that one of the previous speakers was saying that he has several low-income landlords who don't have access to legal services. Legal Aid of Sonoma County does provide services to low-income landlords, and so he is welcome to refer his low-income landlord clients to Legal Aid of Sonoma County. Pending a conflict, we do represent them, and we certainly would be happy to provide training and education to those landlords so that they understand the nuances of this law, and including that the removal of the waste provision does not prohibit them from seeking eviction in all of the examples that have been given tonight. Thank you.
Thank you, Sunny. The next person is Margia. Margia, I'm going to invite you into the meeting.
Hi, thanks so much for having this meeting. My wife and I are elderly. We have one property that we rent in Petaluma, and it's our retirement program. Based on this ordinance, we will consider selling it. We'll probably sell it to an owner occupant because being a landlord in Petaluma looks increasingly risky. So I think that if this ordinance goes through, there are going to be fewer rentals available in Petaluma. And that's all I've got. Thank you.
Thank you so much. The next person that's on my list is Anahi Gomez. Anahi, you are in the meeting. You may unmute and speak now.
Hi. I only have a comment and a feedback about this whole meeting in general. I understand that the goal was to hear the community and hear every comment. I want to say that Hispanics make like 25% of the community. And I don't feel that the comment from the Spanish speaking lady earlier was heard by Eric or Dylan at all. She did have great points about the income. The cost of moving out and the timing. And just the way it was handled, it made the experience feel more intimidating for someone who does not speak Spanish and want to share their opinion. And for that reason, I think it was just a little messy, and not messy, but less encouraging for the other community members to speak up. And
Thank you, Anahi, and my apologies personally for not having that system orchestrated better. We'll keep practicing and try to get better. So thank you very much. Next speaker is Will Sopper. Will, I'm going to invite you into the meeting and you may speak now.
Hi, good evening. Thank you all for staying on late with us to hear the community speak. I know you're all probably wanting to go home and it's late. So I'll try and keep this brief, but I am a donor to legal aid and I have been for years. I was a renter much longer than I have been a homeowner in Petaluma. And this entire ordinance as it is presented or drafted does concern me. I read through it today. One of my biggest concerns was that there are spelling mistakes in it, which makes me concerned that not everyone that we are relying on has really read it word for word. But I'm curious why there is who established that properties that were built in the last 15 years are exempted from this, and what's the basis for it? How was that determined? I'm curious if council members who own rental properties in Petaluma will abstain from voting on this ordinance because it's a direct financial conflict. I'm also curious, and maybe Elise can answer this at a future meeting, how she feels about the effect on seniors who rely on rental income for their retirement and their sustenance in the community, and whether she thinks that that is something that will benefit the seniors of our community that she represents. I believe Diana earlier spoke about suffrage for tenants, and there's nothing in the ordinance that speaks to what happens to landlords when they have an interest rate adjustment on their loan, or there is a property tax readjustment because of a tax that got voted on, or a tax for school bonds, and how that affects the ability to increase rent and co-share those costs with the tenant. And nothing in the ordinance speaks to inflation, which all of us have been subject to, whether we own or whether we rent. And I feel like the ordinance is very one-sided towards tenants only. And I think we've heard that tonight as well, as property owners and investors have spoken about sharing in harm or financial cost. And I feel like everything that's written so far is very one-sided towards the tenant. Nothing in here speaks about what percentage of homes in Petaluma are occupied by tenants. I don't feel like there's a lot of basis or financial information or statistics to support anyone voting on this at this point in time. And I do appreciate you all staying late to hear us. Thank you very much.
Thank you, Will. I just want to acknowledge the next person on my list is Clayton Engstrom. Clayton, you have spoken. I don't know if I didn't lower your hand or if you raised your hand again. I'm going to complete our list and then I'll circle back to you. So the next person on my list is Christopher Marlowe.
Sorry, Ingrid, before you move on, I think there was a question, at least one in the last comments, and I want to respond to that just briefly.
Thank you.
The exception for units that have received certificates of occupancy in the last 15 years is in the Tenant Protection Act. So that's in the state law. That's where that came from, and that is not an exception recognized in the city's regulations. So I just wanted to respond to that. Thanks.
Yeah, and I'll just add, I would imagine the rationale for that is to try to encourage new housing and new units being built. But like Eric said, that's not an exemption under our ordinance.
Thank you. So Christopher Marlowe, you're next.
Yes, thank you. Can you hear me?
Yes, we can hear you.
Thank you very much. I just want to say that Will, who just preceded me, was about the most cogent person that I've heard to date. I am, to let you know my colors, what I think would be considered a mom and pop investor in real estate. The provisions that are proposed are such that, as another speaker previously mentioned, are such that we as investors will leave the market. Anyone who has understood basic economics knows that investors who leave the market means that the market will decline. I would like to know simply, there have been multiple opinions stated to date. How will we know that these opinions have been recorded and properly transferred to the council members who will make the ultimate decision, and how we can, from now till, if I understand correctly, February 4th, make our opinions known to those council members. Thank you.
Thank you, Christopher. So February 4th will be another meeting like the one tonight. So it will be us listening to community members, residents. The March 6th workshop is when we will be presenting everything that we've heard in this meeting and other meetings through our website, through emails to the city council. This meeting is going to be recorded and will be a public record for the city council to review. So those are the ways that we are going to be passing this feedback along.
In addition, another way that folks can verify as to whether staff are doing a good job relaying the comments that have been received is to look at the agenda materials that are being provided for the March 6th workshop for the city council. And you need not rely on us. If you prefer not, you can submit your comments in writing. You can submit them to the emails that staff have mentioned, and we'll mention again before we conclude. And you can also submit them directly to the clerk's office, and they'll be included in the meeting record for the workshop. So those are all ways that you can make sure your thoughts are before the council.
Thank you, Christopher. The next speaker I have is Danielle Rath. Danielle, you may unmute.
All right. Hi, I'm Daniel Rath. I'm an attorney in Petaluma. I've represented landlords and tenants before. I guess I'll try and hit the main points as well. The small points that other people have already hit as fast as I can. So I guess one of the questions that I had regarding the eviction for waste, or the sublease, the no eviction or the no provision regarding an exemption for evictions for subleases. Are they going to have, or will tenants have an opportunity to cure nuisances or waste under the Petaluma statute, or will the landlord be able to serve just a regular 3-day notice to quit?
Well, as you've noted, and I think another prior speaker noted, nuisance is preserved as a lawful basis for terminating a rental agreement in the city's regulations, as it is in the Tenant Protection Act. So, so subject to those two laws, that nuisance continues to be a basis. There's also just the material breach basis, which, as Dylan has noted, and I think this is an area where it would be helpful to clarify our regulations, because it might be viewed as ambiguous. Those still are recognized in the current regulations as lawful bases for terminating. Okay, sorry.
I understand that. I was asking if the tenant would have the opportunity to cure, whether under the regulation it would be a 3-day notice to perform or quit, or rather than just a 3-day notice to quit.
Well, I think that
No.
we don't address that specifically in the regulations.
Okay.
It would depend on the timing of the notice and those proceedings, or whether the landlord wanted to give a cure opportunity, and that was addressed
Okay.
in the notice.
Okay, all right. Moving on, the right of first refusal for applying for 10 years is pretty onerous. I would just add my voice to that. I do want to mention that along the lines of whether or not it makes sense to adopt this, the more confusing your ordinances are, the more specific these ordinances are, or that regulations are for landlords, the harder it's going to be for mom and pop landlords, smaller landlords, as opposed to corporations to navigate them. When you have a different set of rules in Petaluma than you do in Santa Rosa, than you do in Sebastopol, that makes it like very difficult on landlords. And what ends up happening is you have just larger landlords coming in that can deal with it. One of the things that I think this basically just came up a few minutes ago, but not having an exemption for properties that have been built within the last 15 years is a huge mistake, because it's going to cause, the reason why even our very liberal democratic legislature included that as part of the Tenant Protection Act was because they did not want to discourage development. Failing to include it as an exemption from Petaluma's ordinance is going to make the housing situation worse. That's my biggest concern with all of this. I think someone from one of the tenants groups spoke out about including government subsidized homes as including them in this list. You run into the same problem with that when you include. Theoretically under this framework, one of the benefits of taking government subsidies would be to avoid the onerous nature of this ordinance. If you remove that incentive, you're going to end up with landlords that, you're making it more likely that landlords are not going to want to accept government subsidies. I understand that there is legislation that basically says that you're not allowed to do that. You're not allowed to discriminate based off of where the payments are coming from. However, landlords will act according to their interest, and I think that would be a mistake. The couple of things I wanted to just correct. At some point, one of you, I don't remember who it was, said that you would be able to terminate a lease or a periodic lease under the Tenant Protection Act. That's actually not true. You need to have just cause. So you cannot do a unjust cause eviction. Even if it's a no fault just cause eviction, there still must be just cause, and those are specifically laid out in the Tenant Protection Act. I'm one of the few attorneys that are doing landlord tenant work as far as I know in the area. I am curious why landlord attorneys weren't. I never heard about the landlord stakeholder meeting, and I guess I'm a little curious why there wasn't any outreach to any landlord attorneys in the area. It sounds like Houston wasn't at that either. Let's see.
Can I ask you, Daniel, how you heard, just out of curiosity, because I don't know, I wouldn't know how to reach out to landlord attorneys specifically. We don't have that data, but how did you hear about this meeting?
I've signed up for all of the emails,
okay,
the Petaluma emails, so that's how I found out about it. If you Google Petaluma landlord attorney, I'm first or second
Okay.
on the list, along with a few of us. So
Okay, that's a point well taken, and I'm glad you got
Yeah.
the notice, and if you're be willing to share it with any of your colleagues, we'll see how we might be able to expand our list. We're adding to our list
I
every
mean,
day.
I appreciate that. I also did speak at the Petaluma City Council meeting, where they were at the last one that they were talking about this stuff. I think only Councilor Barnacle reached out to me. And King, but he and I live in we share an office. We're in the same building, so that's how I knew him. Yeah, I guess just generally, if you are taking notes in terms of how things can go better, there are so many protections for tenants that are already out there. Most unlawful detainer law is very favorable to tenants, notwithstanding some of the comments that have been made here. My recommendation would be to focus on getting tenants, but it's absolutely true that a lot of tenants aren't aware of what their rights are. It would make a lot more sense to spend efforts trying to get them the resources so that way they can find out what their rights are, rather than making things significantly more difficult on landlords that are trying to act in good faith and be reasonable stewards of properties. I think the last little note I had here. So I'd had my hand raised for, I think, 2 hours now at this point. And I was curious why I ended up being called on after somebody who had come on 45 minutes ago, or at least 45 minutes ago, when she said that she had just come on 45 minutes ago. Is there a way to better organize these things so that way people who show up late and sign up late will end up getting called on later rather than earlier? That would be, I guess, another little feedback that I had here. And I think, and then the last question was for Elise. Is there a way that I can get signed up as a resource for landlords? Because you said that you have a list of resources there.
I believe you are on the list, Daniel. So
I am? Okay.
I will double check, but I'm pretty sure you're on the list.
Okay, all right, thank you. Oh, and I'm sorry, there is one more note that I had here. Providing attorney's fees for tenants in the event that they are successful in an unlawful detainer is a recipe for bad actors. This is something that, and I don't think anybody has talked about this yet, so I did want to bring it up. Landlords who are dealing with bad actors on the tenant side really do not have a lot of, they don't have an easy way to collect when something goes wrong. Because often what we refer to in the industry as professional tenants, these are tenants that tend to move in, take advantage of landlords, cause a whole bunch of damage, commit waste, steal. Sometimes they'll steal copper from the home. They generally don't have any assets to go after anyway. So even if we get a judgment against them for $20,000, it's basically not worth the paper that it's printed on. That's not how, on the other side, landlords always have an asset because they always at least have the property that's at stake there. By having an attorney's fees provision in there, you encourage some of these professional tenants to create problems and then face eviction, and then use that as leverage in order to try and force a cash for keys situation. That is, I have dealt with that in jurisdictions where they had provisions like that, where you could do that. And considering that there are already a lot of resources out there, like legal aid for tenants that are facing eviction, that there really isn't a reason for doing that. And I will tell you that, that's, I made the same joke about this at the city council meeting, but This is one where it really is going to help me if you include that attorney's fees provision in there, because that's going to make my life a lot easier, because then I can represent tenants. So the fact that I'm bringing up that's a potential problem.
Daniel, thank you for your comments. And I think we've got that last one. Did you have anything to add? Because we still have several people we haven't heard from yet that we want to get to.
No, that was my last comment. Thank you.
Thank you very
Thank
much.
you, Daniel. And for anyone who's listening, my Zoom gives me hands raised in the order that they're raised, and I'm just going in that order. So hopefully that feels fair. The next person is Mark Van B. Mark, you are in the meeting.
Hi, thank you for this meeting. I am a tenant, been a tenant in Petaluma since I've been here. And I've been listening to all the feedback. And I've read the act. I do believe it is out of balance against the landlords. I have a question. And I do believe that there needs to be more discussion from the community with you folks and who've written the ordinance to bring in a fairness to that. I appreciate what the attorney just spoke. I think that's great information for you folks to reapproach your ordinance. Also, I have a question, and perhaps it's more toward the attorney, but can the tenant and the landlord, when they enter into a contract, is it possible for them to waive the ordinance on their contract? Is that a legal, acceptable legal thing to do if indeed this ordinance is out of balance?
We haven't provided that right, Mark, in the ordinance. We would need to do it expressly. And the concern, I think, related to that would be that tenants may be coerced to waive their rights under the ordinance. That may be something that we want to address expressly for the benefit of clarity, like some of the other things we've talked about tonight.
Right.
Often regulations like these will expressly state that it is against public policy and a violation of the regulations to seek to have them waived. And so
yeah, I guess that would be contract language, that attorneys would have to review. But I do appreciate all the feedback from both sides. But in listening, I do have to side with the landlords on this, and after reading the act. So I would hope that the city would reapproach this and bring more equity into the equation for both parties. It's a great town. We have great landlords and tenants, and I think it all could be amicable. So thank you very much.
Thank you.
Thank you, Mark. The next person, I'm going to circle back to the person on the telephone, starting with 880, in case you were able to reestablish your audio.
Ingrid, this is Carrie Davison. I guess that was me, although I don't have that phone number.
I don't know why. So
I guess I was a little confused over that, but and I'll just keep this really brief because I've been waiting 2.5 hours. But originally, I think that property managers, and I guess for those that don't know, I have managed property in Petaluma for 31 years. I was born and raised in Petaluma, and my clients consist of tenants and owners, and we treat them all equally. And I do not think there is a problem that exists in this town at all. I think this ordinance came as a safety net for the COVID restrictions going away, and it was never necessary. We have, as property managers and landlords, provided a lot of data to try to prove that there isn't a problem here. And the state law, AB 1482, is protecting tenants in a way that no other state in the country is protecting their tenants, and why Petaluma feels they need to take the next step in punishing landlords when it's not necessary. I think Dave King at the first city council meeting where this came to light, Dave King said, we don't know that there's a problem. Why don't we take about 6 months and see if any problems come forward and then vote on it? Well, that didn't go over, unfortunately, because I thought that was very wise on Dave's part. There isn't a problem here that we have been able to recognize. And we feel very, we love our tenants and our landlords are extremely generous. And I think this whole situation is, like others have said, is going to move landlords out of the market. There's going to be less available rental inventory, and rents will go up and tenants will suffer. And that is not what we are trying to accomplish here. So thank you for listening, and I'll see you on Saturday.
Thank you. Okay, so I have Matthew. I feel like the names I'm seeing up. Matthew, and then I'll go to Carolyn. Oh, Carolyn. Okay. Matthew, you may unmute and speak if you're still here.
I should be here. Can you hear me now?
Yes.
Fabulous. Yeah, I got cut off earlier. Somehow it didn't hurt. Thank you very much for the opportunity to be heard during these very valuable and very timely discussions. To make it brief, everybody's been sitting here for 2.5 hours. I believe the TPA for the state of California enacted in 2019 is more than adequate to protect anybody in the city of Petaluma. Please don't turn my city of Petaluma into San Francisco. The owners, let me say, the burden right now with enacting this legislation is clearly on the landlord. I am thinking of becoming a landlord. And if this passes, there's not a chance I'm going to. It's just ridiculous. It's going to take property out of the housing market. It's going to increase it. And to address a couple other things on it, the mindset that does is, one of the speakers earlier said that the new ordinance even said that nobody has to go ahead and pay a tenant who's getting out because they've already put that. They just don't have to basically take the last month's rent. This kind of logic is just not taught in math anymore. Whether you pay them or whether you don't pay them, this kind of logic is just, let's be honest, the burden is on the landlord when it hits. Another thing is that somebody briefly spoke about is this was emergency legislation that was going ahead and passed during very, very difficult times, addressing an issue greater than all this, COVID, something like this. It's passed. It's drifting out there. We don't know to go ahead and use this emergency as a pretext to go ahead and get a certain type of legislation passed. It's wrong. Another thing, the city attorney, and I appreciate all your input there, but at one point you actually made a comment about, when you're dealing with the issue of waste. Waste is a very, somebody's mentioned, it's very, very difficult to go ahead and have property, repaired after these things. And the city attorney spoke that some landlords use this as a pretext to get people out. I believe in the court system. If there's a pretext that somebody's using in the pleadings, you can go to the certain page and you can read that. And if there's a problem with that, the judicial system will deal with that. Stating that landlords use pretexts to do it, just saying the same thing like, gee whiz, tenants are using pretexts for something like this. I think we need to look at everyone factually. And the last thing, of course, that I wanted to put is that including anything that's single family dwellings for people like this, it's going to take the market for resale for people that we've talked about before or have actually spoken here that have used their real estate actually as their income for retirement, so like this. It's going to blow the bubble right out. And then to further address a lot of these issues, which are in the penumbra and elephant in the room, is the actual housing crisis by itself. I would implore the city of Petaluma to relax some of its statutes on the building, get a grip of this ADU. There's so many places in the city of Petaluma that could actually benefit by an accessory dwelling unit. And I could say, myself included, I think I'd put the brakes on that right now if that unit would be included in this. So I would implore you to go ahead and rely on the governance of the state of California and the TPA enacted in 2019 and abandon this fruitless endeavor. Thank you.
Thank you, Matthew. Carolyn. Sorry, they move around when I go to this list. Carolyn, you may unmute and speak.
Hi, thank you, Ingrid team. This is Carolyn Gavriloff, Westgate Real Estate in Petaluma. We have shared, I just want to reiterate that with Carrie Davidson had mentioned that we have communicated our data. This ordinance was enacted with the assumption that this is actually happening in Petaluma, that landlords are evicting tenants without cause. And we provided data that show that that's not the case. And I also wanted to just address the one question that one of the tenant advocate speakers mentioned, which was that the data that you shared tonight was changed or different than the presentation that we received. It was not. That was exactly the same information that staff has not updated that information. That was the same information that we received at our stakeholder meeting as well. And I just want to reiterate what Carrie said about there really isn't an issue in Petaluma where landlords are asking people to vacate. And I just want to leave one thought, and that is I have shared this ordinance with all of my owners who are mom and pop single family owners, as I am. And unilaterally, they have come back with the same response, which is, Carolyn, I love my tenants. We aren't going to do anything. We're not going to change anything now. We love our tenants. But when they vacate, because as we communicated to you, 86% of our termination of tenancies come from the tenants leaving the homes, not owner driven. And they say to me, Carolyn, when this tenant moves out, maybe we'll consider something else to do with our rental, because housing prices are up. Prop 19 has affected our housing stock, and they can't transfer their tax basis. So we're going to see these homes transition to single family owned homes in Petaluma, which means that everybody is going to be pushed to the apartments in Petaluma. People want homes in Petaluma. They want to have a yard. They want to raise their kids next to their schools. And what we're doing with this ordinance is making it less attractive for our single family homeowners to keep their properties. And I just want to leave you with that thought. Thank you.
Thank you, Carolyn. Christopher Marlowe, are you still with us? I think he may have already spoken and I just didn't lower his hand. So I'm going to take Christopher down. And then the last person we have is and Clayton. I didn't know if you wanted to speak again. I see Clayton. I'm gonna circle back. I've got a couple of hands of people that have already spoken. We're way past our time, so this is going to be brief. Clayton, was there something else you wanted to add?
Yes, certainly. I want to speak to the whole concept of renting houses. As a landlord, what a tenant is doing is buying time in a house. And to make this or to adopt this ordinance and make it punitive because I made a very bad choice on a tenant and make it retroactive to day one, even to make it on 6 months. Let me express to you the cost of re-renting a house when I've made a mistake, and I have made my share of mistakes, big mistakes on the wrong tenants that are so abusive to the other neighbors in a property that I've had to ask them to leave. And you don't know going in if that's the situation. You need to correct it. You need to vacate that unit, and to have to pay them back time is just, it just doesn't make any kind of sense. They've paid for time. When you have a cell phone, a subscription to the Argus Courier, what have you, you've used that time up. And then to have me pay what you call relocation, that's addition to it is essentially giving back their time. Wow, what a wonderful concept. So that's certainly one of the issues I want to speak about. And the next one is there are talking about fees that the city is going to collect if I choose to take my rental off the market. Have those fees been established as to what those are? Because it says the first thing I have to do is pay a fee to the city. You know, sometimes I have to pay permits up front. and all these sort of nebulous things that aren't really spelled out. What is the fee that I pay to the city to take my property off the market?
Hi, Clayton, I can answer that
Thank you,
question.
Clayton.
So the fee is not established yet, and if it does in the future, if this ordinance goes through, if that fee is part of the ordinance that council adopts, it would need to go through a resolution through council. We would need to provide what the costs for the city staff to review and handle the property going off the market. And currently right now, I think what that staff time and the resources that would cost would be staff to file that in our database, just so we have those records in case the property is re-rented, we can notify the tenants. So it would be very minimal, but those costs would be provided as part of an exhibit for any resolution that establishes the fees.
So just to summarize that briefly, Clayton, there's authority in the ordinance to, if the council later chooses to adopt a regulatory fee to cover the cost of implementing the regulations, but it has not been established, it would need to go through a public process before that happened. So there is no fee currently.
Before I call on the next person, I'm going to go ahead and share my screen for just maybe 30 seconds. I want those of you that are here to be able to access the website and the email where we'll be accepting feedback, where you can sign up to continue to stay informed. For those that need to log off, I just want to give you all a minute to see that. Again, it's landlord tenant protections at cityofpetaluma.org. That's an email that you can send directly to us, or you can go to our website, cityofpetaluma.org/tenant protections. There's a sign up form there where you can provide your name and email so we can make sure and inform you. Please share this with colleagues, neighbors, friends, help us get the word out. Also, there is information about workshops. There is information about the current ordinance. And as we can, we will be uploading information that we receive as comments and feedback throughout the process as we get ready for the city council workshop in March. Okay, I'm going to stop sharing my screen. I'll share this again before we log off. There are a few hands. I see a new name, so I'm going to go to the new name before I go to the two repeat names. The new name is Amanda. Hi, Amanda. You can unmute if you're still with us. Amanda, are you there? Oh, there you are. Okay.
I'm here. I'm really sorry. I think I raised my hand by accident. So
Oh,
very
no worries.
sorry.
Okay, well, thank you.
I'm all good. Thank you so much. If I could just say a quick word since I'm on, just thank you so much to all of you who were leading, facilitating this meeting. You've heard so many different viewpoints from people, and I greatly appreciate. I am a tenant. And I appreciate greatly everything that's been spoken by you. You've been very fair, very, it's been a very good meeting. So anyway, thanks again. And that's it for me. So have a good evening,
Amanda.
everyone.
Thank you for hanging in there with us so late. Okay, Will, you are the next person on my list. So I'm gonna open it up. If you have a question, a new question, hopefully, you're welcome to jump in at this time. Or maybe that's a holdover hand. Will, did you have any other questions?
Can you hear me okay?
Yeah.
Sorry, I'll be quick. I forgot a couple things last time. And I also want to congratulate the 5 of you left. Thank you all for staying with us. Earlier, there were over 100 people, and the fact that our city representatives and stakeholders on the committee have left, including our city manager, I think is pretty abysmal. So for those of you that are left, thank you so much for staying with us. Dylan, there was a comment you made earlier.
By the way.
Yeah, I just want to say all the people that were here are still here. They just turned their videos off. Yeah.
There was a comment, Dylan, that you made earlier about LLCs, which I believe that your statement is incorrect. there are provisions in the draft ordinance for LLCs to be exempted from it. So you might want to recheck that. Second, I'm curious also why extended care facilities and licensed care facilities and places that care for our disabled and elders are exempted from this as well. The other piece that I wanted to just quickly raise is that your email addresses and your opportunities for persons to ask questions, there is no email address that is landlordprotections@cityofpetaluma.org. How do landlords feel safe coming to the city to ask you about guidance on this without hiring their own legal counsel for something that you are enacting? I think it's a little odd that it's all tenant driven, not landlord driven as well, based on the comments tonight that were from a number of caring people who do treat their tenants well.
Thank you, Will.
Yeah, and I'll just address one point too. Will, good point about the landlords. We differentiate how we define landlords and owners. And the reason there is for the owner move back in or owner's family, the ordinance doesn't allow that to be an LLC, or you need to own at least, I forget what it is, but it doesn't allow LLCs or corporate entities that own a certain percentage or less to move back in. So there is a difference between there. So thank you.
Okay, next person is Christopher. Christopher, did you still want to speak? No, I think he's no longer with us. Okay, I'm going to lower that hand. Sorry, losing track now. Marcia Harris.
Hi.
Hi, Marcia.
Hi. Okay, I have one question first. How is the ordinance treating school-aged children? Say they've been given notice to vacate, maybe it's a 60 or 90-day notice, the family, but they have school-aged children. Can you address that, please?
You want me to, Eric? I can handle it.
Sure, go ahead, Dylan. I'll supplement as needed. Sure.
Sure. So for the no fault evictions, owner withdrawal, owner move back in, there is the notice of termination needs to be given in the school year or the summer, sorry, not to interfere with the school year for those students. So that is between K to 18 years or 12th grade. And then the other difference is for the relocation fees. It would be an additional 50% there, besides the 100% for owner withdrawal, owner move back in. And the reason there is that tenant households with students, it might cost a little bit extra for them to relocate. So any other questions, Marcia?
Thank you, Dylan. And can I just want to clarify one thing, and that is that the protections for teachers and K through 12 students are teachers and K through students in Petaluma.
Right. My question there is, you mentioned a family owner that wants to move back in. What if it's an owner that has severe illness, needs to sell the home in order to pay for this illness?
That's a good point. There is provisions for if the owner needs to move back into their house for disability reasons, there's some limited exemptions under that for the landlords.
Right, but this would be he needs to sell so he can get medical care in another facility.
I don't think the ordinance limits your ability to sell.
It does not. The question is whether or not the sale is subject to a tenancy.
Right.
But you're right, Ingrid. The ordinance does not preclude sale of rental properties.
Okay,
so I guess in that situation, oh, go for it, Marcia.
No, go ahead. In that situation.
I was just gonna Yeah, at that situation, I mean, you're always, like Ingrid, Eric said, able to sell the home, and it would be the new property owner would have to do that eviction. And then there is the educator K through 12 exemption there that they would have to deal with.
Right, but if you couldn't sell the home with the tenant in place, then you have a problem. So, okay, I know everyone's spoken, and I just want to reiterate, first of all, I'm a 53-year resident of Petaluma. I have been a tenant in my life. My children have been tenants, so I have a feeling for them. I'm also a homeowner and a landlord. And I do feel this ordinance is highly, highly in favor of the tenant and does punish the landlord. There's no reason to have this ordinance. I completely agree with Carrie Davidson. There is absolutely no reason to have this. And I think it needs to be abandoned, and no more time and effort should be wasted on it. And I'm sorry, but that's my feeling. And I really want to thank you all for hearing me tonight.
Thank you, Marcia. I have one more hand up, and then I'm going to go ahead and wrap up and close the meeting. Bonnie Parks, you're going to be our last speaker tonight. Bonnie, you may unmute. There you go.
Thank you. I just wanted to make a comment again about Marcia's question, being able to sell the house. And it's just simply not true, because in order for a buyer to buy the house and live in it and give that notice for the tenant to move themselves, they can't get their loan. They're required by a lender when they're getting an owner-occupied loan to move into the house within 60 days. If you have to give the tenant 120 days notice to move, or perhaps a year if they're 62 or older, or perhaps wait until July if they have a school student, then you simply can't sell it. A buyer can't buy it. You can put it up for sale, but a buyer cannot buy the home to live in it themselves. So you're left with investors buying it, which aren't going to be buying in Petaluma. So I just wanted to address that one thing that I think is really critical. Owners need to be able to sell their property. Life happens. They have changes, especially older owners that may need to be going into a retirement community, or this may be their entire retirement. You know, it's just want to say, I think that needs to be clarified, that this is restricting their ability to do that. That's all. So thank you for your time.
Thank you, Bonnie. I want to share my screen just for another minute. Thank you, everyone, for spending several hours with us tonight and allowing us to share with you the ordinance that the council approved back in September. And they specifically asked us to do our very best to reconnect with our community, share this information, get thoughts and feedback, and continue the discussion. So we really appreciate your time. Let me share my screen just to remind you all that tonight is not the only night. We've got many weeks now between now and our hearing in March, where the council will then have the opportunity to hear this feedback directly and give us direction for next steps. So again, the council adopted an interim ordinance so that we would have time to have this conversation, given that some other protections were going to expire back in September. So the goal was to carry this through until we could have this conversation. And it's a complicated ordinance. It's a complicated discussion. So thank you for bearing with us and all the details, obviously very important. Thank you again. The email here is landlordtenantprotections@cityofpetaluma.org. And the webpage with information about the interim ordinance and where you can sign up and get more information is cityofpetaluma.org/tenant protections. So thank you so much. I think, Eric, did I forget anything? Or I think we're gonna go ahead and close the meeting and
I think that covers it, Ingrid. Thank you very much. Thanks to the city team. Thanks to our translators. Thank you, Ingrid. Thanks, folks, for attending the discussion. And please avail yourself of the resources on the website and share your thoughts.
All right. Good night, everyone.
Good night.